Check, 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 check.
साहब क्या आए हमारे बंदे कोई नहीं पेंशन देखते हैं मुझे पूरे में देखते हैं वो आता है देख
Should we, Mr. Solicitor, should we ask the Advocate General on what is the latest status?
Yes, yes. And whatever assistance we can, I'm here.
Mr. Advocate General, what is the status now? Your note is here on the screen before us, but you can tell us. We'll take
We
the
did
report.
have a detailed meeting of the committee headed by the Honorable Chief Justice. Plus, so far as the redevelopment of the PWD buildings, etc., it was decided that instead of a redevelopment, the structural audit as suggested by VJTI should be carried out. And now, accordingly, the High Court will make a proposal for sanction of the amount, and that will be expedited.
Yes.
And the next target for handing over of land is of December. Is being worked upon. The Honorable Chief Justice has impressed upon all the officers that that target should be met, and steps are being taken in that regard.
Anything else, Mr.
So far as the architects are concerned, some of the architects have already given their designs, etc., and expression of interest. And a PMC is to be appointed. That step is also to be initiated now for appointment of a project management consultant. And the next meeting, the Honorable Chief Justice has called immediately after reopening on 12th of 13th of November to assess everything.
Anything else, Dr. Saraf?
Not really, my lord. Your lordship had last time inquired about the provision of some space in the Air India building for mediation center. On that, at the meeting, the input of the officers was that the possession of the Air India building has still not been received by the state government. The Honorable Chief Justice has again asked the officers to confirm that and make a positive statement at the next meeting in this regard, my lords.
Okay.
So that's where it stands, my lords, and we are regularly monitoring the targets, and my lords, we are working towards it.
Okay. Mr. Thakkar, anything else that you would like to add?
The time being, my lord, let us wait, my lord, till what happens in the November meeting with the Chief Justice about Air India building, so that we know something about some development there and what happens to PWD building.
Mr. Naik is not there today.
No.
Anybody else? Mr. Joshi, anything in particular that you would like to flag?
Nothing to be added, my lord. Everything has been stated by Honorable the AG, sir. So that is the same position, sir.
Mr. Mehta?
Nothing, my lord,
Mr. Solicitor?
Yes, sir.
Anything else from your
knowledge?
Let's make us. The learned Advocate General, Dr. Birendra Saraf, the learned Advocate General of Maharashtra, has apprised the court of the up-to-date status or the status of the building project, and has also submitted a note. From the submission before the court, the following position emerges: bracket 1. The next tranche of the land is to be made available to for the purpose of the construction of the buildings for the High Court in December 2024, and the time schedule would be maintained by the state government. Bracket 2. Expressions of interest have been furnished by the architects, and a PMC would be appointed in a reasonable time frame. 3. The regular meetings have been convened by the Honorable Chief Justice of the High Court of Judicial at Bombay, and the next meeting for monitoring the progress is to take place on 12-13 November 2024. 4. As of now, the possession of the Air India building has not been received by the officials of the state, has not been received by the state government, and hence the proposal for the mediation center has not yet been taken to its logical conclusion. And bracket 4, as regards the PWD building, within the presence of the High Court, the structural report which has been submitted by the VJTI, a structural report has been called for from VJTI and would be implemented. Full stop. Since the ongoing work of construction is being now monitored by the committee of the High Court, we stand over these proceedings to so and so January 2024. An updated status report may be submitted to this court for the hearing on the next occasion. This topic, the litigation date in the middle of the first week, so that January.
Please, Raj.
Please, Raj.
Grateful.
Thank you, Doctor. Thank you, Solicitor.
Thank you.
With my lord's kind
Yes,
indulgence.
Mr. Deepika?
My lords had actually allowed a certain mentioning in a pharmaceutical patent matter in which my lords had actually passed an order on 2nd of August 2024, where a review is actually pending. There's an application that's actually pending for an open court hearing. Could my lords
That
kindly?
I'll take a call on. The open court, of course, it's by circulation first, the
Okay.
colleagues take a call.
May it please,
Kindly-
my lords.
I'm a party to that,
Yes.
that all right.
The order was passed, my lords.
My lords, this writ petition that
Great.
was filed regarding pension for short service commission officers, your lordships issued notice in May. It's been 6 months now, and it's been mentioned 3 times for not to be deleted.
Matters which
No, no, I
were
understand.
of an earlier
Your
date.
lordships indicated not to be deleted. It's been deleted every single time despite that. It's listed for tomorrow. Let it just come tomorrow.
Lords,
It's very
Lords,
okay.
I may mention this SLP, which is a special coal batch matter,
Sure.
which is listed as item
Fresh
29.
matter.
No, it was a fresh matter, which was tagged with item number 29 today.
Sure.
Then, my lords, it went to another court. Your lordship gave me leave to mention.
Lord, I am for the CBI. If my lords,
Lords, this is tagged with those. My lords, so I mentioned to the other court. So, court said you seek clarification whether that court will hear or this court will hear. My SLP is tagged with all the matters here.
All right.
Same issue.
I'll just see what. it is.
Very well.
My
But
lords,
your
the
lordships,
check
can
for
you give
limit-
minutes?
may I make a
Detailed
request?
minutes. Canon India, my matter has nothing to do with that one. No notice was given in my matter and for the
Have
respondent.
you spoken to the to Mr. Venkatraman, who's appeared?
My
in
lords, my lords, in this matter, para 35, the High Court relies on canon and dispose of the matter.
Oh,
Millets,
It
my lords,
relies
my
on
counsel,
canon and says we
your
don't have
lordships on it.
jurisdiction.
one second.
Yes, ma'am.
After the canon judgment comes, you mention and then tell us that then restore it if there are other issues to be decided. But just wait for the judgment to come, then we'll take
Yes.
it.
Yeah, make a motion
Just a second.
for listing of an MA, my lords, and a disposed of SLP. I'm only requesting
What
with
it
listed.
will be broken.
My lords, that we commencing from the 4th, my lords.
MAs are
Yes,
processed because most MAs are
My
not
lords, we are
maintainable.
seeking some clarification of an order. My lords, their lordship was also, so my lords, if it can be listed for the last week, the week after.
What
Diwali.
clarification?
Well, the clarification of an order where your lordship passed an order that this is Miller's proceeding against a settlement order passed by SEBI. Your lordship specifically said that this can only be done in certain Miller's proceedings which are emanating. Now, Miller's, there are certain other proceedings that are going on before SAT. We'd like to use it there. That's the limited
Will
clarification.
not issue any clarification. Let the registry process the MA.
Ah.
They process the MA.
Please, Your Lordships. Your Lordships, I wanted to mention one matter in which the stay order was passed against me in 2021, Your Lordship. Now the date has
Circulate
been
and
shown, Your Lordships, the 12th of November. I just want that the matter should not be
We'll
deleted
see.
from that.
Just
I've already
give your
filed
email.
my name of
Then
mention.
to be liberty to mention what I.
I mentioned, your lordship, that Great Indian Bustard
We have
matter.
a. Yes, Great Indian Bustard.
Was to be listed in September. The report is there.
The report come now pursuant to our order.
It's come.
तो आप ऐसा कर लो वो मैटर दिवाली के बाद लगा दो because now the report has come we'll have to pass final order.
It's showing for 8th of November. It's showing for 8th of November. It's showing for 8th of November already.
Anybody else?
My lords, I request to mention a fresh matter. My lords, I had sent an email yesterday. My lords,
When was the matter when was the impugned order passed?
my lords, the impugned order was passed in August, but
August.
there was an extension order by the
You
High
mentioned
Court.
it yesterday also or no?
My lords, a direction had
When,
come to
when,
issue
did
the
you
matter
previous,
today. my lords.
when did you previously mention the matter?
My lord, yesterday, my lord. My lord, there was an extension by the High Court. The extension expires today, my lord. I had mentioned
Matter would
yesterday.
have been look. You can't choose your dates of your asking. You will, because judges are overworked.
Yes, Manoj.
Even last night, I must have circulated for today about 100 matters.
Manoj, that my
I
mistake was
circulated
that
100 matters last night for judges before I left for home. That means the judges, after I left, which was more like 7:30, quarter to 8, judges were then given 100 matters to read several benches. So have some concern. We'll be,
Manoj,
it will be listed. It will be listed.
one,
But I give priority to bail, anticipatory bail, because we are now closing.
Manoj, this is a disposition, Manoj. Manoj, my matter was there in the list for today, Manoj. I could not clear the defects yesterday, Manoj. I'm just asking.
Maybe it was not listed because the proof of service not filed.
Yes, Manoj.
You didn't file proof of service.
Manoj, I got to know about it at 9, Manoj. That is why I
You
find
have to
it.
be aware of the. You have to be aware of procedures. But he will still do it. He'll still list it. No difficulty.
Grateful, Manoj.
May I mention a matter? I'm seeking permission to file rejoinder affidavit.
All right.
Grateful.
My lord, my father is a paralysis patient, my lord.
Yes.
Regarding pension, my lord. 19.4.
Item plan. Yes.
May I mention a matter? I'm a parting person. I filed a PIL. It's not listed as yet.
It's a fresh matter.
It's a fresh matter.
It will be listed.
Manoj, I just want an early hearing because the difficulty
It
is
will be listed once it's registered.
acceptance, Manoj. Since morning, there's no defect as of now.
When did you file it?
I filed last night, Manoj.
So they give the registry a little time to check the defects. It will be listed. But they require a little time, no? Because a day or so they require, yes. Item 1. Yep, item 1 is the Rajasthan.
The learned solicitor was here.
We had asked last time for a tabulated chart of those who had got less than 15. What were their marks in the written?
We have it ready, Manoj, but the learned solicitor will have something.
We'll just roll it over. Let the solicitor come. I think better that we can. Let the solicitor come. Don't interrupt. Let the solicitor come. Don't you understand English? Yes. All right.
I also filed.
Fair enough.
There is a tabulated form. So kindly.
We don't want your tabulated form. We've asked the solicitor.
Very well, Mike. I don't.
Grateful.
Yeah.
Because I favor the petitioner, Manoj, in our respectful submission, this is not a correct approach.
Actually, correct me if I'm wrong, there were as many as 10 claims which were awarded. Some in part, some in whole.
That's right.
Now, the cess issue is the only issue which the High Court discusses.
Yeah.
They say, and cess is 3 crores out of 21 crores. No discussion on the rest at all.
Cess is admittedly not payable. There's a Labour Commissioner's award. So they paid it. So the
assuming that's your case is assuming that they were right on cess. What about the other 18 crores?
That's right, but it's
there's a patent problem here. Otherwise, with an interim order, we wouldn't interfere. High Court has directed the issuance of a bank guarantee instead of deposit. Yes. The only thing, Mr. Sundaram, is this. About 10 claims have been awarded to them. The award is about 21 crores. Right? Now, the High Court discusses only cess.
One more issue.
And High Court then says you are not a flyby operator or something like that. But it's a
I'm a statutory port. That's what the High Court meant. You're a statutory port.
It's
a government.
money decree.
My lord, I'm on a slightly different point. My lord, it's not only cess. There's also a defense is there many claim is on idling time for boulders which they encountered. They were meant to do dredging. Right. They say they encountered boulders. And the movement of boulders. It is our case that is not something for which they can claim extra, because when you're doing dredging, you are going to find boulders anyway. There is a case on the other aspect. Perhaps the learned judge spent more time on this point, but he has also noticed our other submissions. Be that as it may, it is my submission, my lords, that if under Order 41, Rule 3, my lords. It's very clear that it is security to be given. The option is given security or deposit. Please just see, my lords, order.
Now they have said bank guarantee.
They've said bank guarantee.
Only thing is that if you deposit, then they can apply for withdrawal against security. It flips the process.
No, I'll put it the other way around. Not in a 34. My lords, this is what I want to point out. I can fully appreciate a 34. My lord knows by the amendment it was brought in where you also have to ask for a stay. Now in 34, the idea was you secure. Now, if it's a question of prepayment, it is not the same. This is an award.
Keep this, come on now. The phone aside now. Why have we got so many of
Firstly, in order directly. Please see order 41 rule 3.
What we will do is, without, I mean, this is not worth spending much time. We will ask for a deposit. We have to pass an equitable order. What we will do is, so Mr. Diwan will press for 100% deposit. We will say you deposit 50% and 50% bank.
Manoj, can I just?
May I just make?
Manoj, may I take one?
I'll tell you, Lord, just a minute. But I'm just telling your lordships. There's a norm which has developed in this court. Yeah, starting with Justice Nariman's judgment, where when the high courts were not passing orders requiring deposit in arbitration cases post 2015, this court has interfered under 136, and now a gradual norm has developed. You're absolutely right. As far as withdrawal is concerned, that has to be on terms. But today, how do you say?
Yeah, there's no application for withdrawal.
So there's no question. But deposit, my lords, now I'll place those orders if your lordship like. This is now developed over here. Finally, we have seeing a. You will recall the vigilance department also.
My lord,
one recent.
Yes, recent, my lord, right? Because we've been following it. The two orders, which is the standard form order.
That Balmer lorries order. Balmer lorries.
Before that, your lordships kindly see order 41 rule 3. Just for a moment, my lords. Because under 36 CPC.
This Balmer lorry, I'll just hand over.
3 of the Arbitration Act refers to order 41.
Please see 41.3. My lord, kindly just see 41.3. Just for a second, 41.3 of the CPC. I'm just reading it out to my lord. No order for stay of execution shall be made under sub-rule 1 or sub-rule 2 unless the court making it is satisfied. A, substantial loss. B, that whatever. C, that security has been given by the applicant for the due performance of such decree or order as may be ultimately be binding. Now the CPC, however, by discretion, the court can say that it can be deposit, but you can't invert it and say deposit is the rule and security is the exception. My lord, 36 itself has brought in the CPC. Now, CPC specifically says, under, please just see this, my lords, order 41, rule 3C, that security has been given by the applicant. For the purpose of stay, it should be seen whether security has been given. Now, in certain cases, your lordship say, no, make a deposit. Now, that is on case-by-case basis. And in a 136, my lord, when the learned judge has exercised his discretion, if it is not a perverse discretion.
That's the easiest thing for us to say. 136 and throw it out.
Well,
so you have to also make arbitration efficacious. And look at it this way. The only discussion by the learned judge is in that aspect.
Well, then let it go back to the learned judge to decide the other matters. But I'm saying that can't be a reason to take order 41 rule 3 as a rule for deposit.
Means another 3 months or 4 months.
Not necessarily, my lord. The learned judge is finishing matters in 2 weeks. I know, my lord, this court, this particular judge is so quick. And let him decide the other matters and consider the other matters. But not, my lords, to say that as a rule, deposit should be there. That is not the rule under 41. The rule under, sorry. The rule under 41 is security. The exception is deposit. What my learned friend says is the rule should be deposit and exception security. My whole point is when you know who the respondent is, that he is good for his debt, and you ask him to give a bank guarantee for the whole amount, in which case, my lords, he is fully secured. Otherwise, we are saying the rule under order 41 is you must deposit.
Leave granted. The appeal arises from an order, an interim order dated 9 September 2024 of a single judge of the High Court of Judicature at Madras in A number 4236 of 2024. In arbitration, sorry, ARB, page 1 pe le lo, huh?
Yes.
OP, comms, commercial division, etc., etc. Next. An arbitral proceeding has taken place between the appellant and the respondent. Full stop. An arbitral award was made by a 3-member tribunal on 7 March 2024. An arbitral proceeding took place between the appellant and the respondent, arising out of an award of arising out of a contract which was executed on 12 August 2015 inter alia for carrying out the work of dredging at the inter alia for carrying out the work of dredging at a container berth dredging within the precincts of the port.
Correct.
Full stop.
Actually, it's in the water. It's in the.
Yeah, really.
But your lordship, in the seabed and in the precincts.
In the seabed and the precincts of the port. Full stop. And the arbitral tribunal, the 3-member arbitral tribunal, made an award dated 7 March 2024, directing the respondent, directing the respondent, to pay to the appellant a sum of INR 21.07 crores towards the claims that were allowed in its favor, semicolon, bracket 2, to pay interest on the amount awarded at the rate of 9% per annum from 15 November 2017 until the date of the award, if payments were made within 3 months, and if not, at the rate of 12% per annum from the date of the award till payment. Stop. The applications under Section 33 of the Arbitration and Conciliation Act were disposed of. The respondent has challenged the arbitral award under Section 34 and moved an application for stay of the execution. Full stop. The High Court has, by its impugned order dated 9 September 2024, granted a stay on the execution of the award conditional on the respondent furnishing a bank guarantee in the sum of rupees 21.07 crores within a period of 8 weeks. Next, assailing the judgment of the High Court, the judgment of the High Court has been assailed by the original claimant to the arbitral proceeding, whose contention is that since the award operates as a money decree under Section 36 of the Arbitration of the Act, the High Court was not justified in directing merely the furnishing of a bank guarantee to the principal amounts. Full stop. Mr. Shyam Diwan, Learned Senior Counsel, while pressing the submission, has urged that a body of precedent has now emerged from this court.
Section 37s, not in 34. Even that judgment is 37.
All right.
A final
confirmation.
Sorry.
That a body of precedent has emerged from this court in terms of which the sanctity of arbitration must be preserved by requiring the deposit of the amount awarded as a condition for the enforcement of as a condition for stay on the enforcement of the award. Next, on the other hand, Mr. Arima Sundaram, Learned Senior Counsel, submitted. Uske pehle, moreover, it was urged that the amended provisions of the Act require that while considering the application for grant of stay of an award for the payment of money, due regard has to be had to the provisions of the Code of Civil Procedure 1908 for the stay of a money decree. In this context, Reliance has been finally it has been urged that in the present case, the award of INR rupees 21 crores covered. Finally, it has been urged that the award of INR rupees 21 crores covered 10 claims, of which 3 were awarded in full and 7 in part. Full stop. The High Court might have been submitted while ordering a stay has essentially furnished only 2 reasons. Full. The first reason pertains to the question of cess, while the only other reason is that the respondent is statutory body is not a into inverted commas fly-by into inverted commas operator. Next, Ms. Arima Sundaram, the Senior Counsel appearing on behalf of the respondent, submits that the amended provisions of the statute incorporate the provisions of the CPC in regard to the ordering of a stay on an award which contains provisions for the payment of money. In this context, it is urged that under Order 41, Rule 3, the requirement is for the furnishing of security, and the deposit of money should not be therefore regarded as a first as the default option. Full stop. Moreover, it was urged that the High Court had, having due regard to the fact that the respondent is a statutory body, correctly held that if security should be furnished in the form of a bank guarantee, and as such, the order should not be interfered with under Article 136 of the Constitution.
It's also that the body of precedents was all under Section 37 appeals, not under 34.
On which Mr. Diwan has relied pertains to the provisions of Section 37.
Appeals against 37 orders.
Appeals under Section 37. Next. Following the amendment brought about by the Arbitration and Conciliation (Amendment) Act 2015 into brackets Act number 3 of 2016, courts into inverted commas, while considering the application for grant of stay in the case of an arbitral award for payment of money, must have due regard to the provisions of the grant of a stay of a money decree under the provisions of the Code of Civil Procedure 1908. Stop. An arbitral award has the status of Section 30. Don't say that. Section 36(1) of the statute indicates that when an application to set aside 36(2), where an application to set aside an arbitral award is being filed under Section 34, the filing of such an application shall not by itself render the award unenforceable unless the court grants an order of stay on the operation of the arbitral award in terms of subsection 3. Full stop. The proviso to subsection 3 stipulates that the court shall, while considering an application for the grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree and the provisions of the Code of Civil Procedure 1908. Full stop. The second proviso, first proviso, the second proviso provides for situations in which the court may grant an unconditional stay. Full stop. The second proviso is in the following terms. So, second proviso copy कर लीजिए page 31 को, PDF 45. Full stop. Hence, from a reading of the above provisions, it is evident that the provision for an unconditional stay is circumscribed by the second proviso. Full stop. Ordinarily, the court must have due regard to the fact that before granting a stay on the execution, the court would be guided by the considerations which are stipulated in the CPC in regard to an arbitration in regard to a money decree. Full stop. Next, in the present case, there's an arbitral award in the amount of approximately rupees 21 crores in favor of the appellant. Full stop. The High Court, while issuing a direction for the furnishing of a bank guarantee, dealt with only one of the claims which was awarded by the arbitral tribunal. Full stop. Namely, that which pertained to the refund of that which pertained to the cess payable. Under what provision was the cess payable?
It's building and other construction workers welfare cess.
वो आपको मिलेगा. Building and other construction workers welfare cess act. Welfare cess act. Full stop. The High Court, apart from discussing the above claim, which was in the amount of approximately rupees 3 crores, the only observation of the High Court on the question of stay was that the petitioner is not a fly-by operator and is a statutory undertaking. Complete. The law cannot be, the law in our view cannot be any different merely because of the status of the respondent as a statutory undertaking. Full stop. In this regard, proceedings.
My Lord, paragraph 8, the court has also gone into other issues by saying the award was passed beyond the terms of the contract. That's with regard to the Boulder claim, which would lead to patent illegality, and also in respect of payment which has already been made by the petitioner. That's been observed in paragraph 8. That was my contention. That's a substantial question. Cess is one of the issues.
Private Limited of West Bengal, 2019, 8 SEC 112, where it was observed, bracket 20, copy kar lijiye. The court also observed, then copy down para 26. Right. Bearing in mind above principles, we are of the view that the High Court was in error in not even considering prima facie the fact that apart from the issue of cess, there was an arbitral award in favor of the appellant in regard to on other claims as well. Under Order 41, Rule 5, the court has the power to direct either a full or part deposit and/or the furnishing of security in respect of the decretal amount. Full stop. Bearing in mind the principles which must guide the determination of the court, there is a view that the order of the High Court would need to be modified, which we do in terms as set out below. Next. In modification of the direction which has been issued by the High Court in the interim judgment dated 9 September 2024, we direct that the respondent shall deposit an amount quantified at 75% of the total amount, inclusive of interest, before the High Court. Inclusive of interest, on or before.
Manoj, at least 50% and 50% what your Lordship indicated earlier, Manoj.
Inclusive of interest, on or before 30th November 2024. 2. Conditional on the deposit of the above amount within the period stipulated, there shall be a stay on the enforcement of the arbitral award.
Manoj.
To stop the award of the order of the High Court shall accordingly stand modified in the above terms. The appeal is allowed accordingly.
Manoj.
Be any expression of interest on the merits of the opinion on the merits of the rather contentions when the petition under section 34 is done.
Manoj.
May it please, ma'am. My lord, the issue here is twofold, my lord. One is whether the mobilization advance which is paid, does it carry interest?
You know,
mobilization advance which has been paid, because it is not
7,67,000, no?
No.
7,60,000.
Yeah, yes, my lord.
Why should we interfere, with then award on the under appeal under section 37, the amount is 7,67,000.
Yes, and also there is about
that reimbursement you made a concession. You've raised it for the first time in 37, not raised before the arbitral tribunal, not before the 34 court.
Because it is in the teeth of the section, I mean, clause 14(1)(b).
Not a case.
Your Lordship will just see for a minute, my lord, that.
But on the second aspect, you raised it for the first time in 37.
No,
first.
It was raised before because our award was also passed against it. It was raised before the single judge. Single judge also negated my contention. Therefore, it was raised again.
Yes, and consistent findings, not a case for any.
Leave it to your Lordship.
Business.
Lorships, the High Court.
Not before a bench of which one of us, my learned brother, is a member.
Oh, I'm sorry, Lorships.
Item 9.
9 तो पहले मैटर के साथ दिया शायद. Item 10.
I am appearing in item 10, my lord.
10, there is a specific bar. It says clause 9.4.5. A candidate claimed with the person with disability quota reservation of the original online application.
Yes, my lord. But
category claimed after submission of application form will not be granted.
May I explain that, my lord? My
Yes.
No, Lord, my respectful submission is.
Yeah. Who wanted to change it in cap round 3?
No, my lord, I had opted. I did not possess the requisite certificate at that time, my lord. Therefore, I could not. My respectful submission, my lord, is this: that
you can't change your category after the process has begun, and you saw the change in round 3 of counselling from general to the PWD.
Yes, my lord, but that has been allowed by the coordinate bench also, my lord. I have annexed those orders also. My lord. So far as the rule is concerned, my lord, which is relied upon by the...
Mr. Patil, there's an express bar in 9.4.5.
Yes, my lord, but my respectful submission is, my lord, that bar applies to the central quota, my lord, and not for the state quota under which I had applied, my lord. I have specific submission. I made that
PWD quota. It says PWD quota.
Yes, for the all India 15% quota, my lord, in the states, central quota. Not for the 85 quota. That is why, my lord.
Change of category, midway. Somebody will say, I got my scheduled caste certificate only midway. Somebody will say, I got my, PWD, persons with disability, this disability certificate only midway. The last date for the submission of applications has to be the last cutoff, actually. Otherwise, how will these lakhs of students apply? It will be impossible for the authorities to.
Lordship may also consider, my lord, that the High Court has.
I think we'll leave it.
Very well.
Grateful.
May it please your lordship. My lord, item number 11 is coming up for the first time after issuance of notice. May I explain in short, my lord? I am a person who is born as a Muslim woman.
Ready with the matter?
Oh, my lords, the prayers are, my lords, your lordships may consider the kindly see the prayers. He's asking as a practicing Muslim who wants to be governed by Indian Succession Act.
But the succession specifically says that you will not apply to a Muslim.
Yes, my lords. So,
my lord, may I say this?
Really is in teeth of the succession.
Yes, my lords.
My lord, may I say this? I am not a practicing Muslim.
UCC is being considered by the government, my lords. We don't know. The legislature will consider it.
If you require consideration, to file a counter since we have issued notice.
Please, my lords, we'll do that.
Then will your lordship kindly.
We'll file a counter.
My lord, I have filed 2 applications. My lord, may I say this? I filed 2 applications after the first hearing.
Let them file a counter.
Yes, ma'am. I filed an application for amendment as per the suggestion from your lordship, means to challenge section 58 of the Indian Succession Act, so far as it excludes Muslims. I filed that application. That is,
have you filed an amendment?
Yes, I filed IA 126417 of 2024 on 27/5.
Yes, my lords.
And my lord, there was another objection by the central government that it should be the law secretary and not the cabinet secretary. I filed an application for amendment. That is amendment of postage bill. That is 213167.
All right.
And
well, it has 3 matters. The first matter, lordships had, when I'm assisting your lordships, because this was a suo motu petition sent by a candidate for Madhya Pradesh. The 2 other writ petitions, Milords, 12.1 and 12.2 relate to Rajasthan. There's also item 14, I think Mr. Farasat is appearing, which is also very important, Milords, which is also relating to reservation for handicap. So if I can just indicate, Milords, briefly, what is the issue in 12.1 first, Milord. Lordships have 12.1. This is filed through a private.
Just 1 second. Yeah, also 1, 2, 6.
Rajasthan only listed today because there are other matters of Madhya Pradesh which are not on board. I must point out before.
Oh, is it? I don't know.
The list only says only Rajasthan.
Only 12.1 and 12.2. My lord, that is covered by my lord's judgment that has come out, my lord.
So can I just assist your lordship with the Rajasthan matters? If Sadan is in item 14, so that may be connected. Lordships, my learned colleague is right. There is a judgment of my lord, which is a 2-judge bench decision presided over by Justice Trivedi, which holds that the action of the state of Rajasthan in not, because can I indicate just
in not specifying a separate cutoff for PWD?
Yes. So can I just indicate the problem with that?
Yes.
I have no difficulty that judgment. If the state doesn't prescribe a separate cutoff, the rules do not permit, that's perfectly fine. But why I'm urging your lordships to consider, and Shadan probably will support me, and he has another point on the rules itself. Suppose, Milords, there is an exam which is held, Milords, like CLAT. I'm just giving an example. CLAT is held. There is a reservation for, like my son took CLAT, there is reservation for persons with disability. If a person gets 30,000 rank in CLAT, I'll assume that means up to top 100 and all are top law schools. Suppose the first PWD candidate gets 30,000 rank in CLAT, he is entitled to admission in whichever college he wants, be it National Law School or Nalsar. So what the person of 30,000 rank is actually studying with my son in Nalsar. So that's one exam, because CLAT can go up to, even if you get 0 marks, you are entitled to an education.
Because there is a horizontal reservation.
There is a horizontal reservation. So the first candidate you go down the list, you will come to even 0 marks is entitled to an admission in a law college. Law college can't deny you admission even if you have got 0 marks in CLAT. Because law colleges don't fix a minimum cutoff. Or say 25 marks is required in CLAT or 50 marks is required in CLAT. Now, Milords, this exam relates to civil judges. Civil judges, there is a preliminary exam held, Milords. Preliminary exam held, everybody takes the exam, including persons with disability. Now, persons with disability may have 40%, 50%, 60% disability, up to say 80% disability. They are not able to perform, obviously, Milords, I mean, for reasons which God has given them some other abilities than the abilities which we think are relevant. Like I had a person who had 5 fingers in hand. Today, the person says you can't do an MBBS course. So these are, but they have other abilities. Like Rahul, because I was interacting with him, he's able to remember all judgments with paragraph numbers, which we don't remember. So they have different abilities. He appears in a preliminary exam. He's entitled to reservation at the end. But what is required, and
yes, what the High Court is saying is that you must have the minimum, you must fulfill the minimum cutoff. Now the cutoff is in the preliminary exam?
In the preliminary exam, and also now in the main exam where Sadan is appearing.
So your clients didn't fulfill the cutoff.
So I'm only assisting a lordship.
Right. We have appointed you as a
my learned colleague is appearing. I'm only assisting because it's tagged with item 12 minutes. So it's tagged. Sorry, just 1 second. Right. No difficulty, Sadan. We are on the same.
My lords.
Also, Mr. Rungta is also here. Very good.
Yes.
Sorry. No, I don't want interrupting at all. No, he says Rajasthan.
Judgment clause. Rule layout. Judgment layout.
That if a person is physically handicapped,
right, bullets.
In that case, if suppose there's a minimum cutoff that in the preliminary exam you must get 40% mark.
Right.
How much was it in Rajasthan?
It's 50. So it goes by their individual category. Suppose you're a general person with disability, you have to get 50%.
Right.
Suppose you're a SC, ST, OBC, then 45.
Because the reservation is horizontal.
The reservation is horizontal. Even
so if you're a general OBC candidate, then you have to get 50.
Some figure. 50
yes. We'll take it as 50.
Yes.
Now, these examinations are held for appointment to a service.
Right, Manoj.
Once you clear the preliminary and the final exam, you're held to be successful after the interview.
Right.
Then irrespective of your position and merit, you will get a job.
Right.
First person will get the job.
No, they have also 40 in the main.
Right.
40 in the
so say for general,
yes,
50% in the preliminary,
right, Manoj.
40% in the main,
right,
and say 30% in the interview.
Right.
Once you have cleared the 3 stages,
yes,
then there'll be a reservation for the category.
Right.
But we are appointing civil judge junior division. How can we say that there'll be no cutoff at all?
No.
So a person who gets 0 will also be.
No, that's not
our case. Can I assist, my lords? I have also moved an application for intervention in this.
One second.
Just 1 second. I'll just complete my submission. Just complete my submission in 5 minutes by the watch. It is not as if there should be no cutoff in the preliminary exam. It's not our case that a person with 0, we are only at the preliminary
exam. Saying that they should fix a separate cutoff.
Suppose, Milas, I'm just giving an example.
For general category, if it is 50,
correct, Milas.
Have a cutoff of 40.
Correct.
Have a relaxation.
And that, if you don't make, if you don't make that, then you are violating RPWD Act because you're not making provision for reasonable accommodation, giving an opportunity to take the main exam. We are only at the taking of the main exam, Milas.
Manoj, may I interrupt? Manoj, 5% relaxation is there to PWD.
How many categories are there? General, then?
General, there are at least 6 I know in Plat. Rajasthan may have. So there is general.
Just then.
OBC. SC. ST.
And for all these categories,
yes,
there are prescribed
cutoffs. Yes.
Okay.
Right.
So this is for the prelims.
Prelims. We are only on prelims. Let's focus on prelims. Yes, Milas.
Followed by mains.
Mains. Yes.
Okay.
Yes.
So when you are talking about 6 categories,
correct, Milas.
And 6 categories have different cutoff marks.
Correct, Milas.
This physically handicapped candidates,
yes,
they will fall in which category?
So they are going by their own batch tag. So if I am general physically handicapped, you follow. Yes, sorry.
They will be placed.
Yes, Milos.
But it's not your grievance is it's not a lower cutoff.
Right, Milos. I am saying you fix the lowest if you are taking an OBC with 40. Right, Milos. I am saying if you are taking an
Let's suppose general has a cutoff of say 55. The cutoff of say 45. SC has a cutoff 40. ST also 40.
For PWD is 5%, no?
So it depends. 4 is the minimum. So now, just once.
So if the seats which are reserved for the PWD have to be earmarked at the outset.
Yes, Milot. That's what we are requesting. Milot. Otherwise, you're denying them an opportunity at the final time. So suppose I just give an example. Suppose there are 100 seats at the end, Milot. Just give an example to your lordships. And I'm not.
Six have to be earmarked.
6 have to be earmarked. Give an opportunity to take the main exams. And then Mr. Farasat will address your lordships on main exams, how it has to be worked. But if you're fixing a 40% cutoff at the preliminary exam, you're not giving an opportunity to them to take the main exam. So here there is a 40% say cutoff for PWD. But you are saying 39-1 will not get it. Now a person with OBC will obviously not having the same disability as a person with disability has, Milot. A OBC candidate suffers from other disabilities, but a person with physical disability, Milot, may have learning disabilities, may have had faced so many other issues in life. Now you are not giving an opportunity even to take the main exam.
And if he takes the or she takes the main exam,
yes,
and they are within the zone of reservation,
right, Milot,
then that first seat will go to him irrespective of his merit.
Absolutely. So this is only because preliminary exam is a elimination exam. You are eliminating these people by judging them on their preliminary.
But are you contending that there should be no cutoff or that it should be a lower cutoff?
Because I was thinking, to be at the highest, I would say you reserve, because today those seats won't go to somebody else. Those seats at the end lapse.
But he says that they give a relaxation of 5 months.
Yes, they give. I'm not saying, that's why I'm going forward. Some may give, because today as an amicus, my duty to assist your lordship for all India perspective. How do your lordships take an exam? Be it preliminary exam for judicial service or preliminary exam for any service. Today, judicial service, your lordships are right. High Court will examine it at the mains and interview at different thresholds, because your lordships would have done it, Milos. All your lordships would have done it. All judges of the court would have examined candidate. But today, what you're doing at the preliminary exam is you are judging him today in that multiple choice questions. Most preliminary exams are multiple choice. You have 6 seats reserved for them, 4 seats reserved for them, maybe 20 seats reserved for them. Take 20, give them because anyway it's not counted for the main exam. Give them an opportunity to write the main exam. That's all we are requesting for today, Milos. If they write a main exam, whatever are the cutoffs, Mr. Farasat will address as to whether it should be lower, not lower,
Time being.
Yes, Milos.
Proceed on the footing that we accept your suggestion.
Correct, Milos.
Your suggestion is that let there be a cutoff, keeping in mind the disability.
Right, Milos.
Okay.
Right, yes.
Now you said there are 6 categories.
Right, Milos.
Today, without a cutoff,
yes,
they will be divided in 6 categories, and they will be governed by the cutoff.
But some have cutoff. Some have cutoff. I just wanted to correct. Some have cutoff.
Now, if we accept this argument of yours,
Milos,
still they will be divided in different categories and then cutoff for each, all 6 categories.
No.
Or then physically disabled candidates, not to be divided in accordance with the categories, but a fixed cutoff.
Yes, Milos. Which should be substantially lower.
That should be the correct approach.
Right.
Preliminary exam.
In the preliminary.
Yes, and you are only making them eligible to take the main exam, Milos.
But now, yes, but we got the point. But now what happens in the main exam?
The main exam now is a real challenge. It's a real challenge. Now, main exam, Milos, I would suggest, and as a Milos today, Milos, just going back a step forward, I'll answer my Lord the Chief Justice's question. Milos, preliminary exams, Milos, when you talk about horizontal reservation, Milos, why is it called horizontal is only this, Milos? And this horizontal concept is people in normal course, suppose I have a disability of more than 45%, suppose I do not have one hand, and take it that it's 40%. I may be doing excellent as a judge. I have no difficulty with working as a judge if I don't have, say, one hand. I may clear the preliminary on my own merit without taking any handicap of the PWD. I may clear the main exam on my own merit. Therefore, your lordships had this concept of horizontal reservation. But when it comes to actually implementation, your lordships find hardly 1 or 2 people actually end up taking the main exam. And therefore, your lordships have to factor in that experience of working of this horizontal reservation for PWD. Unlike women reservation, because women is also horizontal. But large number of women actually make it.
They make it.
They make it to the main without that 30.
The category which is otherwise handicapped.
Handicap.
We are only, it's the
Representative.
reservation is to ensure better representation.
Representation. And what it does, Milas, what it does is very important.
In fact, for all we know, the cutoff in the women's category may be higher than
Maybe higher.
cutoff.
Maybe higher. So all horizontal reservations, Milas, like Karnataka reservation in National Law School, Milas. Today, I think, Milas, except 1 or 2 candidates, all people in the main list itself are from Karnataka. Or largely from Bangalore schools. So suppose 130, like my son was, I can take my son's example, 130 is the cutoff for general category. Maybe 1 or 2 people at 133 or 134 maybe from Karnataka. So horizontal reservation was meant not to provide exclusive, but our experience in 8 years has suggested that in large number of exams, especially judicial service, what we find is that large number of persons with disability are not in a position to write the main exams because the threshold is kept at 40%, which is suppose 40%, general is 50%, I'll take it, because that cutoff plus large number of candidates make it to the main exam in OBC, EWS, OBC, because they do not suffer the handicap of learning, the problems that they face in school.
So at least they should be given an even chance to go to the next
level.
But in that level now, suppose for the main exam, the cutoff is say 40%. What do you do there?
Yeah, that's I'll request Saddam to address. I have prepared
Well,
for this.
We'd like to also see the rules.
Yes.
What do the rules say?
Yes, rules say. So rules, if the rules suppose say that you will have 40%, the question will arise, does it serve the purposes of the PWD Act? Suppose the Act is a, sorry.
What is the stage today now? The results of the preliminary exam were declared?
Yes, results were declared. So
the 15th of July 24, right?
Correct.
So now we are in October. What is happening?
Main exam has been held, and therefore Rajasthan and lordships are considering now item 1, except all our Rajasthan cases, where the English language.
They didn't, but those people appeared for the exam.
Yes.
These people didn't appear for the exam.
One person actually, item, your client appeared for the main exam.
I have the mains.
So 11, just give it.
I'm at the mains for the interview. That's my case, slightly different from Mr. Agarwal.
No, I'm not in any case. I'm just putting a logical figure. So suppose Milos in Rajasthan, the learned colleague can give the right figures. Suppose there were 220 vacancies, if I'm not mistaken. Is it correct?
222 vacancies.
220 vacancies. And if I'm not mistaken, at least 15-20 seats.
9 were reserved for
PWD candidates.
Correct.
Factually, 11 people made it to the main exam. Factually. 11 people did write the main exam. But what this petition...
Now tell us one thing, at the main exam,
yes.
Suppose the cutoff is, how much was the cutoff at the main exam?
For general, it is 131.5. For
general.
Out of?
300.
They have applied the cutoff now. See, that's the main, there's a difference between cutoff and minimum.
No, I'm not saying cutoff. Was there a minimum mark required in the main exam?
Well, it's in 2 steps. One is that they must secure 35% each in the law exams and 40% in aggregate. That is the eligibility. But then it is subject to a further proviso that we call 3 times the number of vacancies.
Yes. That's yes.
There the cutoff sets in. Because if there are 100 vacancies, we will call 300. But there could be 400 who are actually qualified.
The cutoff has to be lowered for PWD candidates.
Yes. Well, the problem there is, the distinction between vertical and horizontal. Now, if we have a separate list of PWD candidates, it will create a different vertical category. That is something which Indra Sani would not allow us.
My lords, can I?
Then what happens?
Can I make some submission, my lords, to clear the air? Because it has a far-reaching implications, my lords.
Eskilung to sir, invited and Murray Arthur. Sir, what is the number?
which is going on.
And sir, what is the IA number, sir?
My intervention is, I'm just giving. In this Rajasthan matter, I had filed the intervention. File number.
डायरी नंबर वही नहीं कमल किशोर मूर्ति वर्सेस राजस्थान
ये नंबर अभिषेक से पूछो नहीं. I'm just giving from the OR.
Sure, sir.
Let's see for a moment what this
One sentence and I'm done.
Yes.
I'm not then interrupt. Suppose my submission is simply this. Suppose your lordships have 10%, 10 seats reserved for the persons with disability. Point one. 15 times the number of candidates are to be called for the main exam, or 10 times. Some Patna has, for example, 10 times. Somebody may have 15 times. If the person at the preliminary stage should not be told that you haven't got 40% in the preliminary or 50% in the preliminary. You should give them an opportunity to take that main exam, because the main exam is actually the exam which decides the merit. So if you have suppose 10 seats reserved for persons with disability, give them 150 persons if they are available, give them 150 an opportunity to write the exam. That's all. Then your lordships will decide. I'm grateful.
22878.
It won't serve any good purpose, Mr. Agarwal.
224.
By doing this, all that is happening is they are getting a chance to appear in the main exam.
Right, Mullahs, but that's how it takes it forward.
The candidate who has not been able to make it in the prelims itself,
right.
You want them to take a chance.
Sometimes it may happen, Miller. Sometimes it may happen. These are persons with disability. We are not.
But assuming that we allow all these people, that there should be no cutoff for persons with disability in the preliminary exam.
Right.
How many are there? Very few, really.
That's what I'm saying. Very few.
But we were just wondering, when it goes to the main,
yes,
maybe very difficult for us to say that there will be no minimum eligibility.
No, that's right. The Sadan will address your lordship. Perhaps that minimum should be there. Cutoff is main. What they are happening.
Cutoff is different.
Different, yes.
Cutoff is different.
So in mains,
we can't, because they are all going to become civil judges. So in the main exam,
you have
suppose for the SC category.
Yes, Vilas, it's 40.
The cutoff, not the cutoff, the eligibility is 40 marks.
40%, yes.
A person who's PWD but an SC must have the minimum eligibility.
Minimum eligibility, yes.
That is but if he is not within the cutoff,
yes,
you must still look at them.
Look at them, yes.
Otherwise, what will happen is they have fulfilled the minimum
eligibility,
but because they were not in the cutoff
for SC, STs, yes.
They were not in the cutoff.
Yes.
For that category.
That category.
Therefore, that person.
That's exactly Sadan's case.
That's my case.
That's
so you fulfill the minimum.
Yes, I do.
He has the minimum.
Cases, I cleared.
Sorry, Milas, I'm sorry. Is there anything else? Can I take the seat?
Yes.
Item 12, Malas, may I submit just one thing, Malas, on the practical.
Now, how many cases do we have today?
Plus 12 and 14. 12, there are 2 writ petitions, but those are petitions.
Mr. Gaurav, you are appearing as amicus in serial number.
So I am amicus in 12.
12.
But 12.1, 12.2 approached me because I was amicus and said, please assist us in this.
Okay.
So since I am assisting your lordships in the first matter, I said I'll just do it to difficulty.
Right.
So these are people who didn't make it from plim to main.
Now tell us.
So that as far as this year is over.
But we have to lay down the law.
The lordship may lay down the. I'm not saying this year the lordships will give them any.
Mr. Rumta, we are not.
Yes, my lords. Am I audible, my lords? Am I audible?
Just 1 second. We are not in a hurry because it's a crucial thing affecting the lives of people and careers of people. We'll just come back to you in a minute. Now, this year is gone.
No, gone, my lord.
But we have to lay down the law.
Absolutely, and that should apply to at least for the prima facie all high courts. Lordship may not say about other services for the time.
Now, what is Justice Bela Trivedi's judgment?
Yes, my lord, that's Shraddhan will just.
May I just place?
We'll come back to you, don't worry. We'll now, after we'll get Shraddhan Farasad for 5 minutes, Mr. Rungta for 2 minutes or 5 minutes, and then we'll come back to you.
Shraddhan, just please.
Yeah, I'll place it. Shraddhan will just have my
All right.
I'll place the judgment.
You are in seal number 12? 14. Who's in 12?
12, because main matter, my learned colleague said that Madhya Pradesh matters is not listed. So 12, your lordship may take it up on next.
My lords, I appear in 12.1 and 12.2.
For the petitioner?
Yes, for the petitioner.
And Mr. Farasad is appearing in
14 for one petitioner.
All right. So 14 and 14 point, there's only 14.
14, there's only one person.
So you are appearing for 12.1 and 12.2.
For the petitioner?
Yes, yes, my lords, for the petitioners in 12.1 and 12.2, there are a total of 7 candidates if both writs are taken together.
All right. What about 12?
12 is the main suo moto, where your lordship's one candidate wrote from Madhya Pradesh.
Oh,
Madhya Pradesh doesn't have visible disability reservation at all.
So 12 is a suo moto.
12 is a suo moto. Lordship may take 12 next Tuesday, Milots, because my learned
12.1, 12.2 we can look at right now.
12.1, 12.2 are on cutoff at preliminary.
And 14 we can.
14 is cut off at the main, Milots.
Also, Lordship,
So we divided our work accordingly.
12 may be a larger issue, but the other high courts may also be required to be.
That will delay.
Lay down the
12, your lordship may just take it immediately.
But at least let's lay down the law on 12.1, 12.2 and
I'm very happy with that. It's no difficulty.
Now, Shraddhan, what do you tell us?
Your lordship will just have the note I've handed over. Just for a moment, just ignore the left-hand column. Just come to the right-hand column. This is my case in this year. I have cleared prelims on, I'm the EWS category, fully blind, 100% visual disability. So I'm EWS category. Prelims I cleared on my own, so that difficulty is not arising in my case. In mains, Malaz, I had 113.5. Now, Malaz, kindly have this rule at rule 23 at the bottom proviso, Malaz, right at the bottom. What my lords were putting, provided further that a candidate belonging to scheduled caste or scheduled tribe category and persons with benchmark disability, that includes me, shall be deemed to be eligible for interview if he has obtained minimum of 30% marks in each of the law papers and 35% marks in the aggregate in the main examination. I have this. I have cleared this. So these numbers I have. Now the challenge for me is 113.5 is not the sufficient cutoff for EWS category.
For?
Or EWS category. I am EWS, economic weaker section. Well, that's the non-backward section which has been introduced to the amendment now. So I'm in the EWS category. 113.5, although it meets with this eligibility criteria in the rule, it doesn't meet with the EWS cutoff for the interview. Now the situation today, the interviews have started happening. Plus they will conclude on Saturday. As of the present schedule, what I need today is to participate in the interview because I have qualified in this eligibility criteria. Now your lordships will have on the left hand side, this is the clause in Justice Trivedi's judgment which was interpreted.
Can we just see the whole of Rule 23, actually the scheme? Let's just see it because we'll get a complete picture. I think let's read the whole of it, I think, and then we read the judgment in...
Well, I'll just hand it over. Just give me a moment.
No, it's here, no? Rule 23, competitive examination.
Correct.
Just read the whole thing.
Yes. The competitive examination for the recruitment to the post of civil judge shall be conducted in 2 stages, that is preliminary examination and main examination. The marks obtained in the preliminary examination by the candidate who are declared qualified for admission to the main examination will not be counted, determining final merit. The number of candidates to be admitted to the main examination will be 15 times the total number of vacancies category wise, but in the said range, all those candidates who secure the same percentage of marks on the last cutoff will be admitted to the main examination. Note, clause A. To qualify for main examination, the candidates of SC/ST category and persons with benchmark disability shall have to secure minimum 40% marks in the preliminary examination.
This you clear?
Yeah, this I clear. Well, I actually also cleared the EWS. This is only qualifying. So I also cleared the EWS qualification. To qualify for main examination, the candidate of all other categories shall have to secure 45% marks in the preliminary examination. Now 3. The number of candidates to be admitted to the interview shall be, as far as practicable, 3 times the total number of vacancies category-wise. Provided that to qualify for interview, a candidate shall have to secure a minimum qualifying 35% marks in each of the law papers and 40% marks in the aggregate in the main examination. Provided further that a candidate belonging to a scheduled caste or scheduled tribe category and persons with benchmark disability shall be deemed to be eligible for interview if he has obtained minimum of 30% marks in each of the law papers and 35% marks in the aggregate in the main exam.
You have qualified, you have fulfilled this also.
This I have fulfilled. But the challenge is that I am not meeting the E because it's horizontal, operating horizontally. The only cutoff they are putting is the EWS, and that EWS cutoff I am not meeting. So, Malas, therefore, you logically just have page 170 in item 14. Interim order was passed, Malas, by another bench. And today, Malas, all I am requesting is just that. Page 170 and extra P8, Malas, in my matter.
Yours is 14.
In item 14, 1/4.
1/4.
Yes, Malas. And we have copies as well if you just want to lose.
No, we have got.
184.
My lords have that page. Annexure P8, PDF 190, 191. PDF 190, 191. Yes. After our order dated 21st.
Okay, that's a slightly different order. Actually.
Yes, no, Malas, in furtherance of our order dated so and so, to take it to its logical, we direct that if any one of these 31, I'm sorry.
We'll pass an interim order. We'll allow him to appear for the interview.
That's all. Absolutely.
Right? Let's see if he doesn't clear the interview, his hard luck. I mean, why should we start with a negative or a cynical assumption? Maybe for all we know, he'll clear the interview. We'll have a good PWD candidate.
All I can submit, my lord, is that we have undertaken the exercise strictly in terms of the rules. Therefore, there is no power of relaxation so far as the.
His rule is this advertisement, no? This thing.
Well, this is the advertisement. This is the term.
Do you have separate rules by any chance?
Yes, yes.
They show us the rules.
Your lordship saw that rule 28, and then, my lord, there's a
Where is it? Where is it?
There's a schedule, my lord, at page 57, 58, which gives the entire scheme.
Well, it's page 19 of my paper book.
Yes, same paper book, my lord. Page 57 is the schedule 4 because ultimately the.
But just show us the rules. Which are the rules?
Yes, these are the RJS rules, my lord.
Give us the PDF page.
Page 41.
71.
Sorry?
PDF page 41.
71 is.
33. Next year P1.
Yes, my lord.
Now, which is the relevant rule?
Rule 10. Plus, we'll have rule 10 at PDF page 41. Reservation of vacancies for SC, ST, OBC, MBC, EWS, person with disability and women.
Yes. No, okay.
Reservation of posts for scheduled caste and scheduled tribes shall be only at the time of initial recruitment in the proportion of 16 and 12% respectively of the vacancies advertised, and same shall be followed in respect of subsequent recruitment also till the ultimate percentage of reservation is reached above. And must kindly have clause 4 of this. Just leave rest of it. Clause 4 is relevant for us. On page PDF 42.
Now, what are the state rules?
Well, I'll just come to rule 5, but just in a minute, kindly have clause 4 first.
We saw it. We saw it.
Yes, you see.
This is a state rule. It
No,
refers
that's
to state rules.
Just 1 second. P76, Malos. PDF 96. And at the bottom of PDF 96. First, Malos, rule 5. Reservation of vacancies. In every establishment, 4% of vacancies of direct recruitment in cadre shall be reserved for persons of class of persons with benchmark disabilities according to.
No, we don't have it.
Plus PDF 96 of the same brief.
No. Page 90, printed page, no?
Plus printed 76. Printed 76. Malons have that?
Yes.
Yes. This is 5. Reservation of vacancies. In every establishment, 4% of the vacancies of direct recruitment in the cadre shall be reserved for persons or class of persons with benchmark disabilities according to Section 34 of the Act. In the post identified for each disability by the Government of India under Section 33, and such reservation shall be treated as horizontal reservation, and the vacancies for persons with benchmark disability shall be maintained as a separate class. Because in fact, I'm relying on this. And that's why in the advertisement separately, it has been benchmark disability has been put for me. So that's all my prayer today is the fact that they are not treating me as a separate class in line with this. Therefore, kindly allow me to participate in the interview till the time this is rectified.
To say about this Rule 5, which just Mr. Farasat read?
Separate class, my lords, in our submission does not mean a separate cutoff. My lords, their only grievance, my lords, their writ petition, the prayer is to declare a separate cutoff. Now, separate class of vacancies, my lords, we are providing 4% reservation. And we have also provided within that 4%, 1% for each category, the visual, the locomotor, and so on. So, my lords, that is being provided.
In the legislation,
The petitioner is a blind candidate. Full stop. Pursuant to advertisement number 783 of 2024, issued on 9 April 2024. Don't say pursuant to, under advertisement. Huh? In advertisement, don't say that. The Rajasthan High Court, in advertisement number 783 of 2024, dated 9 April 2024, announced recruitment, announced the commencement of the recruitment process for direct recruitment to the cadre of civil judge, Justice Bela Trivedi's judgment.
Yes, sir.
For direct recruitment to the cadre of civil judge, 2024. 9 vacancies. We just see this and then we continue to case.
I was fortunate to be part of that litigation also. All these aspects were actually pleaded by us. It's there in the...
No, there's a fundamental distinction in the rule which was interpreted here and in our case. And that distinction in the chart, there was no separate eligibility for benchmark disability in that second proviso.
No, even for preliminary values, there's a relaxation of 5%. Similar to what we have for the interviews.
Well, the rules here are extracted at page 5 of the judgment.
Yes.
The advertisement. And here there is no category for benchmark disability people. It was only SC/ST. 15.3 proviso, just have that. At page 5 of the judgment. 15.3 proviso. And that's why I handed over that chart. In my case, in that proviso now, there is a separate eligibility criteria which I meet. So that's a clean point of distinction from this judgment. And para 10, in fact, that's what they rely upon. Kindly have para 10 at page 8 of this judgment. Para 10, at page 8. Apart from the fact that there was nothing provided in the advertisement for the fixation of cutoff marks for the persons with benchmark disabilities. Because in my case, there's at least the eligibility benchmark disability has been provided. So that's the point of distinction. I'm distinguishing this judgment.
There's no difference, my lord, as far as our submission goes, because even for the prelims, there is a basic eligibility, my lords. 40% for.
And this was anyways for prelims, and I'm on mains, my lords.
Yes, but they are similar terms.
Only if I may be informed. Please.
Were reserved for persons with benchmark disabilities, of which 2 are for persons belonging to the blind and low vision category. Your synopsis is correct, no?
Yes.
The advertisement also stated that the number of candidates to be admitted to the interview shall be, as far as practicable, 3 times the total number of vacancies category-wise. The next. Sorry. The advertisement, which was issued on 9 April 2024, contains clause 23 pertaining to the scheme and syllabus of the examination, which is reproduced below. ये separate chart में right side का column लेना है ना? I just mark it as AA. Next. Rule 10 of the Rajasthan Judicial Service Rules 2010 provides for reservation of vacancies for scheduled castes, scheduled tribes, other backward classes, more backward classes, economically weaker sections, and persons with disabilities, wo underline kar lijiye, persons with disabilities, and women candidates. Rule 10 bracket 4 is in the following terms. Copy down at PDF page 36. Rule 10 bracket 4 inter alia makes a reference to the rules of the state issued from time to time. Full stop. The state of Rajasthan has issued a notification dated 23 January 2019 in terms of prescribing rules called the Rajasthan Rights of Persons with Disabilities Rules 2018 under section 101 of the Rights of Persons with Disabilities Act 2016. Full stop. Rule Chapter 3 of the rules, Rule 5 of the rules prescribes for reservation of vacancies in the following terms. Rule 5.1 बोल दो, हाँ? In the present case, the petitioner appeared for the preliminary examination and secured the minimum of 40% in the preliminary, and secured the minimum eligibility, secured the requisite marks
For qualifying to the mains.
for qualifying for the mains in terms of the PWD category.
EW category.
At the main examination.
Yes.
At the main examination, the petitioner scored 113.5 marks. Full stop. However, he has not been called for. He has not been called for interview on the ground that he fails to fulfill the cutoff
For the EWS category.
for the EWS category to which he belongs. Next. At this stage, it was material to note that in terms of the proviso to clause 23 of the scheme and syllabus of the examination, it has been provided that a candidate, a cutoff, a minimum eligibility has been provided of a minimum of 30% marks in each of the law papers and 35% marks in the aggregate in the main examination for SC, ST, for SC and ST candidates and for persons with benchmark disabilities. The petitioner has admittedly fulfilled this criterion. Let's stop. The attention of the court has been drawn to a judgment of a two-judge bench of this court in Rekha Sharma versus the Rajasthan High Court, Civil Appeal 5051 of 2023, delivered on 21 August 2024. Prima facie at this stage, it appears, however, that in that next. Don't say next. In the course of the judgment, two-judge bench referred to the judgment in Indira Sawhney versus Union of India, 1992, Supplementary 3 SEC 217. More particularly, paragraph 812, which reads as follows. ये copy down कर ले मैम के judgment में बेला त्रिवेदी मैम के at page 9. The court has clarified that reservations for the physically handicapped into inverted category are horizontal in nature, in the sense that they cut across vertical reservations. Full stop. The person selected against this quota will be placed in the appropriate category. Candidate, for instance, belongs to the SC category. Such a candidate will be placed in that quota by making necessary adjustments. Full stop. In other words, once selected, the candidate would be placed in the category to which he or she belongs after making necessary adjustments. Full stop. In the present case, admittedly, the petitioner has fulfilled the requisite eligibility criterion, the minimum eligibility norm for being called for the interview, as stipulated in the proviso to clause 23 of the scheme and syllabus of the examination, as noted above. Full stop. In this backdrop, at this stage, since the interviews are to take place on Saturday, the date value
going on,
and
it will conclude what's ongoing. So it will conclude on Saturday.
Will conclude on Saturday. We pass the following order. The petitioner shall be called for the interview as part of the ongoing interview process. Full stop. That's all that we need to. And shall be duly assessed by the committee during the course of the interview. Full stop. We issue notice, Mr. We have already issued notice. The respondent shall file their counter within a period of 1 week on or before Friday, next Friday. List on, we'll keep this matter on Monday and we'll dispose it off.
I'm so grateful to the court. So grateful.
Mr. Siddharth Sharma, you are here in the court?
Yes.
Okay.
So, Mr. Sharma, you can appear for the interview on Saturday. Best of luck to you.
My lords, may only say subject the selection, the appointment will be subject to the outcome.
That's all right. Yeah. One more candidate makes it. What difference does it make? We want these candidates in the service.
My lords, may not be treated.
If he doesn't qualify,
my lords, the apprehension is that others will also try to.
So let them come in. Let more PWD candidates come in. Why should we be worried about it? Study harder, Mr. Sharma. You don't let us down now at the interview.
Very right, Your Lordships.
That's grateful to the court.
My lords, if I only may be allowed to say something in respect of.
Now, what about 12.1 and 12.2?
My lords, I was coming to 12.1 and 12.2. My lords, this situation as described by my learned senior in the main examination is the exact same situation in the prelims as well.
What about her?
My lords, they did not qualify for the mains. They were unsuccessful in the prelims. And now, my lords, mains have taken place. Now, interview process.
Your matter will issue notice, I think. We'll have to set down the law. You'll file your counter. This we can't do anything today for you because for the reason that, they'll let the counter come. We list it on the Monday after we reopen.
Yes, sir.
My lord, the reply has already been filed by the.
We list it on Monday before final disposal. We let that earlier matter come. Yes. And Mr. Agarwal, what you can do is just give us a little note.
Yes, my lords. Yes.
On the rules, etc. Then we'll take it. We'll close it for orders and we'll deliver it.
Yes, yes.
I have also moved an application for intervention.
You're traveling in the
By Saturday, I'll file it, my lords.
By Saturday,
yes,
you can file.
It will be on your lordship's record, my lords, by Monday. I'll ensure it's there,
my lords. May I also be permitted to file a short note, my lords? I have moved.
Agarwal, learned Damicus Cure, and Mr. S.K. Rumta appearing for the intervener to file brief notes of submission. The Council for the State of Rajasthan may also do so. The submissions shall be emailed to the court master at whatever email ID by Saturday, 5 p.m. on Saturday.
By 5 p.m. and lordship may take it on Monday.
And we'll list it on Monday. So
grateful to you.
So grateful, Your Lordship.
Item 12, main matter, Your Lordship will fix up on some other day.
Main matter we can then fix up some other day. Keep it after 4 weeks. This matter will take up.
This matter is easily with the data before your lordship service.
Yes. Council for High Court. My lords, may only correct, my lords. Council for High Court.
Council for the High Court.
Rajasthan. Grateful to you.
So on.
That's really.
Hmm. 30th September को नहीं सुनी। May it please, my lord. My lords, on 30th of September, my lord, your lordships were pleased to issue notice, and my lords direct that one seat, my lord, which is available for the Children of Gallantry Award, will not be de-reserved, my lord, till the next date of.
Who's appearing for the respondents?
My lord, I'm appearing on behalf of respondent number 1 university, my lord. We have kept one seat reserved, my lord. That in fact the process of counselling is already over yesterday, my lord.
But there is
one seat reserved in the Dan Medical College as per directions of this.
There is a stray round, my lord, which is yet to happen. And my lords, as far as our, my lords, information goes, there is no other candidate, my lord, under the category of Children of Gallantry Award officials in the entire state of Punjab. Lords, I am already studying in the NRI quota. Lord, let me be considered in the mop-up round or the stray round, my lord, as far as this category is concerned. And my lords, the lordships may decide the main issue, because, my lord, the judgment of the High Court is in the teeth of Anushka's, my lord, judgment, which your lordship said that prior to 2021, my lord, whoever had got OCI, lords, they will be entitled on par with Indian citizens, my lord, to participate in examinations, medical, etc. Now, my lords, I have got the OCI in 2018. Now, my lords, to my misfortune, when I applied in the first round of counseling, my lord, in the website, there was no, my lord's, provision for, my lord, OCI. It only said citizen. I can't make a wrong, my lord's, representation of a citizen. That I have said so particularly. High Court, my lord, shuts me out by saying you've applied under the NRI quota, not in the general quota as Indian citizen. So, and says that you have not challenged that particular part of the prospectus, which is ex facie against the judgment of this court.
Now, under the judgment of our court in Anushka,
Yes,
Ringundpar versus Union of India,
yes, ma'am.
Somebody who holds an OCI card before 4th March 21,
correct, my lord,
is entitled to be considered
as, my lord, an NRI citizen, and NRI citizens are on par with, my lord's, Indian citizen. That your lordships will find if your lordship straight away have the your lordship's judgment at page 72. At page, my lord.
But you, there was no category at all in that advertisement, is it, for NRIs?
Not for.
No, there was for NRIs.
For NRIs, but not for OCIs, my lord.
OCI. But what is the relevance of 4th March 21 in the judgment in Anushka's case?
My lord, what happened, my lord? There was a notification which, my lord, the government issued on 4th of March 21, categorically saying that OCI, my lord's, card holders will not be entitled to be treated on par with Indian citizens. That was held to be prospective. If your lordships have the judgment straight away, my lord, starts at page 72.
You could have applied on that NRI thing, na?
I have applied under the NRI.
Just
yes.
a minute.
Yes.
If NRI has to be construed as all those persons who have obtained OCI prior to 21 as Indian citizens, then they should have.
Correct, Lord. But there was a stipulation in the prospectus. If your lordships have that stipulation, my lord, only in Punjab, which is completely contrary, my lords, to your lordship's judgment at page 334. But the problem was, my lord, because of one judgment, my lord. Your lordships wanted to see the judgment.
Yes.
Page 72, it starts, my lord. And the page 72, my lord, PDF, page 106.
Should be 15.
Annexure, my lord, P15.
Got it. And which is the relevant part?
Yes, my lord. The issue, my lord, is in paragraph 3. When this was the position, page, my lords, 115 PDF, paragraph 3. When this was the position, respondent number 1 issued notification of 4th of March 21 in exercise of the power under 7B of the 1955 Act, whereunder the existing right of appearing for the entrance exam to compete with Indian citizens for the seat was taken away and restricted the admission only as against the seats reserved for NRIs or for supernumerary seats. The proviso to clause 4.2 of the notification dated 4th March 21, in fact clarifies that the OCI card holders shall not be eligible for admission against any seat reserved exclusively for Indian citizens. So this was the issue, my lord. And in paragraph 19, at page, my lord's PDF page 127, the court notes the existing position prior to, my lord, 4th of March, paragraph 19. Through the said notification of 5th of January 2009, the OCI card holders were given the right to pursue the professions indicated therein in India and also to appear for the All India medical test or such other test to make them eligible for admission in pursuance of the provisions contained in the relevant acts. Since NRIs had parity with the Indian citizens in that regard, the same benefit became extended to OCI holders, including the petitioners therein. And ultimately, my lord.
Therefore,
yes, my lord.
Prima facie, it appears from page 4 of the impugned order.
Yes.
According to the High Court, you should have applied in open category and not in NRI.
Yes.
You understood that I must apply as an NRI.
Yes, my lord.
And because I have an OCI of 18, I should be treated as if I am in an open category.
My lords, I could not apply under open because the first entry on the open that I have put, my lord, says Indian citizen, my lord.
Therefore, come to page 4
yes,
of the impugned order. And read,
that's the first impugned order.
Read para 4.
Yes, my lord.
This is the impugned order, no?
Yes, my lord. There are two impugned orders. The first impugned order is of 10th of September for the first round. And there is a second impugned order, my lord.
So in the order of 10th September,
yes,
High Court says undoubtedly the Supreme Court in Anushka
yes, my lord.
and Pallavi
yes.
held that OCI card holders are entitled to be considered as Indian citizens if the card was issued up to 4/3/21. However, in this case, he neither applied for open category within the prescribed time nor came to the court within reservation.
Correct, my lord.
This is how the court
my lord, the interesting thing is, this was for the first round. In the second round, my lords, my lords, came up with a physical copy. And after that, the court has completely renegated on what it observes at page 4. Now it says Anushka never held that OCI card holders are on par with, my lord, Indian citizens for the second round. That's my grievance.
No, but OCI card holders prior to 4th March 2021
yes, my lord.
were given the status of...
but the High Court says no in the second...
Oh, where is that relevant part from Anushka's case?
Yes, my lord, the relevant operative portion, my lord.
Alright, before that, where does the High Court say that?
My lords, kindly see the second impugned order.
Page 16, my lord.
Yes, my lord.
Page 16, paragraph 3.1, my lord.
Page 19, my lord. Kindly see page 19, PDF page, my lord, 53. It nowhere, middle of that page, my lord. The noting, my lords, Anushka, it nowhere stated OCI card holders shall be treated as Indian citizens for all intent and purposes. The Supreme Court has laid down that the notification of 4th March 21 represents a step towards retrogression and therefore shall not have a retroactive effect. However, the notification has not been questioned set aside. It is evident that clause 4.2 provides that OCI card holders shall be at par with NRIs, so and so. They were never granted parity with Indian citizens. This is completely wrong. Now, my lords, kindly see, my lords, my peculiar situation. On the first, my lords, writ is filed, my lords, on 31st of August 2024, when the first round, my lord, of counselling starts. My lords, there I go to the High Court and say that I was unable to fill, my lords, the online form as far as OCI is concerned, because the entry, if your lordship sees the form itself, Lord, the first entry says Indian citizen. I can't apply as an Indian citizen, and that the form lordships will kindly see.
You always knew that. Look, as an OCI card holder,
Yes.
prior to 4/3/21, you were always at par with an Indian citizen.
Lord, but I can't say in the form, my lords. You have to say whether you are an Indian citizen or not. Please see, that's the problem.
Let's hear Mr. Bansal. Mr. Bansal, what do you have to say?
Lord, I have only two submissions to make. First, my lord, because he is challenging the, my lord, the conditions of the prospectus, particularly condition 17 subclause 6, my lord, where, my lord, NRIs are, my lord, required, the OCI are required to be applied only under NRI category, my lord, not in any other, my lord, category. That's one, my lord, condition which has been discussed by the.
What is the condition?
Page 334.
My lord, may kindly just turn to, my lord, I am the university. I am bound by the, my lord, guidelines and the instructions issued by the state of Punjab. So, my lord, the last instruction on the on the basis of which we have issued the prospectus, my lord, is at page 353, my lord.
What PDF page would that be?
My lord, I'll just.
Condition PDF page is at 367, my lord.
367, my lord. Just but that is the notification of the government on the basis of which we had issued the prospectus. This my lord, notification is of 9th of August, my lord. 9th of August 2024.
Admission or no?
Lord, I have got admission under the NRI quota
in fact,
in college.
In that college.
In that college, my lord, there is one seat which is still vacant. If they can consider me for that, and lordships may decide this matter, the NRI quota can be released.
It's very easy for the petitioner to make all these submissions.
My lord will earn more money. Lord, I am a son of a retired.
That's the problem. That's the whole problem.
Than the NRI quota.
Yes, Lord.
But he has already got the admission in
1 crore.
He applied it at NRI quota. My lord, he has submitted the. He has deposited.
He's the son of a retired.
Process is complete. Now the dispute is with respect to the fees.
I'm sorry, my lord.
Yet you could deposit 1 crore.
No, my lords. Lord, I have taken my lord's help from people. Yes, my entire my lords, my savings have.
May I maybe permit
the interim order?
Friends.
I'm sorry, my lord.
Little help from friends.
My lords, for the entire PPF, my lords, I have withdrawn and I put it in this thing. My lord, the High Court has been a little uncharitable.
May I make submission?
The High Court has dealt with it, my lord.
All right, yes.
Give me 1 minute.
Yes.
My lord, I'm sorry. My lord, the factual.
Page you are referring to page 353, is it?
My lord, that is page 353, my lord. That is the notification, my lord.
No, that's not the notification. We have the prospectus.
But that is the part of the prospectus. This notification is part B of the prospectus. It is the part of the prospectus which was issued by the.
So what are you reading?
So, my lord, I am reading clause 17. If my lord may kindly see. First of all, my lord may kindly see clause 11, my lord, 354, clause 11.
Just 1 second. We'll just try and track this actually.
Clause 11, my lord. But he is seeking admission at the state quota of 85%.
Not getting that.
Ludhiana, my lord.
And the college now you want admission?
Yes, my lord. Same.
The factual position is, my lord, that he applied under the NRI quota. He got the seat in NRI quota in the very first round, my lord. He deposited the fees under the NRI quota. He is already admitted in the Dayanand Medical College. After the, my lord, seeking admission, now, my lord, on 31st August, my lord, he files the writ petition, first writ petition in the High Court, my lord. Challenging the, my lord, the admission process itself is the application process is complete on my lord, the 16th of August, my lord. The only dispute, my lord, in this case.
You are referring to page 333, right? Clause 17?
Yes, my lord. Clause 17, page 333. Precisely. My lord, it says that, my lord, the OCI card holders, clause 6, my lord.
OCI PIO candidates shall be considered only for
as NRI
quota.
Yes, my lord. So that is how I am bound by the government instruction, my lord. I cannot do it on my own. So, my lord, it has to be the government who has to respond, my lord. Respond number 2. I don't know whether they are there or not. That is first submission. Second submission is, my lord, that, my lord, the prospectus was issued on 9th of August, my lord. He files the writ petition. First writ petition is on 31st August when the whole process is complete. Not before that, my lord. If he has to challenge the conditions of the prospectus,
file it immediately.
He should have filed it immediately. That is what the High Court says, my lord, in the second writ petition. That he comes late, my lord. The second writ petition has been dismissed in the question of laches, my lord.
Lord, the
Can you
process
see
form of
the
interpretation.
observations?
No, there is no delay,
Now
my
the
lord.
process is complete. Fees is admitted. He is already what he is seeking, my lord, is basically he wants to shift the quota after seeking admission in one quota where the fees is a bit higher than the lower quota. That's all. That's
That's
the
the refund of that crore rupees which he pays.
My lord, kindly see, my lord, 9th of August, my lord, the prospectus, my lord, was issued.
When did you file your petition?
My lord, petition was filed on 31st. The process was ongoing because I was unable to apply, my lord. The process was ongoing. And the High Court says you have not challenged.
You made it in the NRI quota.
Yes.
My lord, my entire retiral benefits, my lord, I have put into this. If I am entitled to, my lord, OCI, my lord, under your lordship's judgment, my lord, how can the state by way of a prospectus say that no, we will have a different, my lord, regime?
He has already deposited $60,000 US for the first, my lord, as per the requirements.
Even as far as the second round is concerned, my lord.
$60,000. Who transferred?
My lord, that is a lump sum, my lord, which is released on retirement. My lord, I have paid in August. He retired in August, my lord.
In dollars?
No, my lord, I have paid in rupees.
Foreign citizen.
Paid in rupees. Yeah.
He's an Indian.
Fees is 110 USD.
The father settled some in foreign country.
No, my lord, he's retired in 2024.
And you?
My lord, I was
He has
abroad.
taken this US citizenship by
I was born in California, my lord.
By virtue of birth, my lord.
By what?
He is staying in Punjab.
My studies have been here, my lord.
All through he has been here.
Born in the US.
Yes, my lord.
Yes, my lord. So he is keeping the US passport, my lord. That is the whole problem. He could have opted for the Indian citizenship way back, my lord. He is keeping the citizenship of United States, my lord, seeks benefit of Indian citizen.
Ultimately, what was the purpose of Anushka, my lord? People had organized their lives, my lord.
Now just leave it at that.
People had organized their lives pursuant to, my lord, the status which was prevailing prior to
the facts now, I think, the fair outcome. Item 14 now.
My lord.
15. 15 now. Who's appearing in 15? Where's the developer's lawyer?
At the very outset, Lord, I'm grateful for the time that your lordship.
Where is he? Where is your learned friend?
Lord, I had informed him.
Now look, what we will do is that first part we have concluded that you will have to pay at rupees 2560 per square feet for the total area of the flat, which is 1800 square feet. We are now left with the maintenance, all right, and interest from which date. Now, maintenance, we will say that the maintenance will be paid with effect from the date on which the demand letter for possession was issued.
Would your lordship want
I tell your client, if he waves his head, you will meet the fate. Aap piche jaiye, sit in the visitors gallery.
Would your lordship quantify?
Go and sit in the visitors gallery. We don't want somebody here to, yes.
Would your lordship quantify the amount?
All right. How much, from the date of the letter of possession, how much is the maintenance? You said 50,000.
I said 50,000. He's calculating from 2012, includes interest on it, and amounts arise at an amount of 6,51,000.
How much does it come? And the letter of possession is from what date?
3rd June 2022. My calculation is 50,100 something.
दिखाओ. We'll fix it at 1 lakh. We'll make it all right. So maintenance, we are fixing it at 1 lakh. Now he has to pay. The last component is interest.
Please.
Lord, the flat is valued at more than 1.5 crore, my lord, 1.25 crore at today, my lords. And what is he paying, my lord? Not more than, my lord, 60 lakhs, my lords. Its value, my lord, at present is more than 1 crore, my lords.
is the balance for the, how much is the balance which you have to pay for the cost of the flat? We had said, I'll just tell you. No, 8 lakhs, no.
No, your lordship's
22.97 lakhs.
That your lordship has already indicated,
Right.
because your lordship
But
can
now,
put on the area of the flat.
Now, you will have to pay 7% interest
Please.
on that 22.97 lakhs.
May I just point
From 2013, my lord, as per the order, my lord.
Your lordship had in the original order said
My lord, para 8 of the order is very clear on the in the interest part, my lord.
Mr. Sahu, not a word from you, please.
I'm so sorry, my lord.
We are putting an end to this litigation. You are a builder. For you, it
That is the only building I developed, my lord.
one flat
Not
or
big
10
builder, my
flats.
lord. That is the only building, my lord. I closed everything, my lord.
That's all. That's all. Keep your mouth shut, please.
Please, my lord.
You are trying to balance the equities. Please.
इसको interest ऐसा कर दें. Seven percent of 23 lakhs, 22.97 lakhs.
Please.
How much does 7% per year come to?
It is 1.6 lakhs, my lord, per year. I have given the calculation on my affidavit, my lord.
वो आप calculate कर लो भैया गुलशन.
It's there at page numbers. Page
22.97.
1,60,000 it will come. However,
61,000 multiplied by
Milords, may I?
Come to, if we take per year, it will be 1,61,000.
Please. But may I just point out something?
1 sec.
Please.
Trying to figure.
Please.
Do is instead of saying, if we take it for the entire 11 years, you will have to pay 17,71,000 as interest.
Please.
You'd fix a lump sum instead of now going into all this.
May I only indicate one thing? Your lordship in the original order had said 7% on the principal amount of 8 lakhs.
That no, yes, sorry.
My lord, that is there. It is very well covered, my lord. All I'm saying is, my lord.
But we have also said that the balance consideration is to be fixed on the 18.
No, 23 lakhs.
Exactly, my lord.
All I'm saying is interest may not be on 23 lakhs. Interest.
You will have to pay interest on 23 lakhs for the reason that the builder is entitled. See, you are entitled to a flat at totally what, 60 lakhs?
Its present value is 1.25 crore, my lord. I just discussed with my client yesterday, my lord.
If ऐसे dictate ऐसा ले लीजिए, we have factored in the requirement of the petitioner to pay interest at the rate of 7% per annum in terms of the order of this court. Full stop. Bearing in mind all the facts and circumstances, we are of the view that the ends of justice would be met if the petitioner is directed to pay a total amount of rupees 35 lakhs, inclusive of the amount of the balance consideration of rupees 22.97 lakhs, which will include the full stop. This amount of rupees 35 lakhs will include both the principal, principal as well as the interest
and the maintenance. Everything.
No, my lord, I may only request, my lord. The outstanding amount as of October 2021 was 46 lakhs.
Interest and the maintenance. So 12 lakhs now which you have to pay extra, 11 lakhs which you have to pay extra. will include your 1 lakh maintenance, it will include 10 lakhs by way of interest.
So, I have to pay a total of 35 lakhs.
Total of 35 lakhs.
Your Lordship, in the original order had indicated at the time of registration of the conveyance.
Yes, that we have said.
My lord, may I only say, my lord, the interest calculation was only up to October 2022, my lords. It has to be calculated as of now. 2 more years have gone, my lords.
We have said, yesterday we have said that shall render the flat fit and habitable in all respects for occupation later than by 7 December. Payment shall be made to the balance consideration and maintenance amount shall be made of the balance of rupees 35 lakhs at the time of the execution of the conveyance. You have to now pay 35 lakhs totally.
Please.
And at the time of the execution of the conveyance to be executed by 7th of December.
7th of December. Grateful. I am so grateful.
After payment, my lord, it has to be, modification has to be carried on, my lord.
Yeah. Fresh matters, we'll just take them for 5 minutes.
16 Lord may not conclude in 2 hours, Lord.
No?
No.
So then that will be, we have reserved Dr. Singhvi's.
That's a different question. In my case, I'm not raising that issue, so I don't know about it.
I filed my note, my lord. You raised that point as well, my lord.
Then we will stand this over. And
I filed my note, my lord.
Mr. Dwivedi was looking at us with consternation yesterday when we were handling Dr. Singhvi's challenge to constitutional validity. Now, discretion is a better part of valor. All right, go beyond the vacation.
I placed my note, my lord. Your lordship had permitted me to file.
Right.
We've also filed a note.
Right.
Lord, can the priest matter be taken?
Dr. Singhvi's matter, we have reserved orders.
Yes, we filed a
Only thing is, in Dr. Singhvi's matter, we will, whether just Pardiwala, we were discussing in the evening, you will have to take a call on that consultative committee's recommendation.
I mentioned in my note, my lords, as to the position that consultative process is ongoing, but states also have been consulted because it will affect the states also.
But you must take a decision.
Been 2.5 years, my lord.
3 months.
2.5 years.
You may say that, look, coal is very different from iron ore, etc., whatever. But once you've adopted the principle of, there being, there should not be a cumulative impact of every month's increase in the royalty. You must take a call. You can't leave it in the lurch. It's entirely your policy decision, but you have to take a decision one way or the other, isn't it?
Absolutely.
So would it be a lordship's pleasure to indicate some date, after 2 weeks, 3 weeks, whatever?
In the middle or 3rd week of November? Okay.
My lord,
take date those, man.
My lord, can the priest matter come on Tuesday, my lord, because the father, they couldn't get tickets last night on Tuesday.
On the reopening.
Lord, that judges matter, my lord, or India judges matter. The judges matter, my lord, the learned AG is doing, my lord. He is traveling, but he is returning tomorrow. But he is returning after an 18-hour flight, my lord. It may be difficult if it can be kept on Monday next.
Okay. That is the wider judges matter. But there is some matter which they are saying is just of the High Court judges who have not got any.
That also, my lord, yesterday I called the officers from the law ministry, but eventually, my lord, all of us felt that he has taken detailed instructions, my lord. A week, my lord, may perhaps not,
That
my
is
lord.
not governed by the NPS issue, no? That is not the NPS issue.
I'm told it is not, my lord. It is not.
That is not governed by. You are appearing there.
Yeah, I am paying Justice Gupta's matter, Lord. Item 37.
On Monday, my lord. Monday next, my lord.
Lordship may have it on Monday.
He is coming, my lord, but 18 hours is too long a flight for him.
As
But,
item
it
1
is 19 and 30.
We'll take it. Yeah.
19 and
37.2.
19 and 37, I think.
19 and 30.
37.2.
36.
So now which matter do we start after lunch? We're starting.
Item 17 again requires a longer hearing, my lord.
Oh, yeah. Now, what about the fresh matters? There are two small fresh matters. Who anybody here in the fresh matters? We can do it then before lunch.
My lordships have 1:30 function also.
Oh yes.
I would not like your lordship's lunch to be curtailed.
I think we'll come back at 2 o'clock.
But 17 to some other day. 17, item 17.
We'll call it out. We'll see after lunch what is to be done in that.
As it is. will not be
into the ERA matter.
but will not be able to. But it has.
Whatever all of you.
We have given the questions to them. They are
formulated.
We have given to them. They are ready to share it with us.
Have you agreed to the questions?
Those questions
with them prepared?
My lords, the questions of law are okay. We have indicated, and even from our side, my lords, any question that's there.
In your appeal, you have agreed to the questions with them.
Questions of law can be asked. Because in our appeals, we have 3 appeals for the Federation of Indian Airlines. We'll also give our questions of law to my learned senior on the other side.
We had said that you have to give the questions in law in advance so that we can finalize the question in law.
Right, today itself we'll give it to
Anyway, Venkatraman has drafted it. I think the other side seems to be agreeable to the questions that Mr. Venkatraman has drafted.
Yes, but we have 3 separate sets of appeals below the separate questions of law in each.
And Lord, may I have to be very realistic on what my friends, Lord, it involves 3 broad concepts and involving 3 tariff periods. One relating to whether OMDA will override ERA or ERA will override OMDA is one issue for one period. Then 2, in determining the tariff, BIAL and DIAL have one set of contracts. BIAL and DIAL. MIAL and DIAL. And BIAL and HIAL, Hyderabad Airport, have a different set of contracts. So we will split this tariff into 2 different parts. And further sub-question, this involves adjudication, final adjudication of 15 years of tariff spread over 3 tariff regimes. And the time taken in TDSAT is weeks. Now to say everything can be compressed in half an hour, I have to.
How long would you take roughly?
AG is also not in station today, he's coming back. If we need the barest is Tuesday, Wednesday, Thursday, we need. It will take, to be very honest, I have to be fair to the court because it's the final adjudication.
And what about your side? How long will you take? He says he'll take 3 days.
Adjust. If my land were to start today, we'll adjust to the shortest time. Lordship fixed time.
No, but he said, Mr. Venkatraman says he will take 3 days, he said.
No, your Lordship will not necessarily accept our time estimate. Your Lordship will have to put some time for both of us.
I have to be fair to. I've always made a fair assessment.
He is very precise. We saw him heard him Tola, Canon, so he does.
My letter is very thorough, but what is your Lordship? I have to put some time in because this matter can be heard and disposed of in the few days available. I don't want Lordships. I understand Lordship.
Tomorrow is of course miscellaneous, and then we are left with Tuesday, Wednesday, Thursday. But you will have to give us time for judgment.
If my learned friend starts, if my learned friend starts, it is correct. It will spill over. But I'm saying on the spillover, it can finish. Your Lordship gives us each fellow's half a day or each 1 day or some limit. I'm prepared to abide by whatever Lordship says.
We can start on Tuesday, we have no problem. But I have to honestly say, when we start, can we finish and your Lordships can deliver is the only
if
question.
If we start today and he takes the next Tuesday, we'll finish in Wednesday.
AG has to lead him.
Essentially only 1 day to write judgment.
No, not.
We have 3 appeals as well of ours.
No.
In 1 day will be very difficult to pen.
That is the 6th I'm talking about.
That's an important formula, which is the foundation for 3.
Unless in all matters you are argued, say it's 1 question or just 2
No, it's not.
Then it's different.
It has 11
we can decide that.
We have put it, it has 11 questions to be decided.
To half a day. That's all I can do.
It has 11 questions. I've mailed it and to be very honest.
So weeks after formulate the questions at least.
Yes.
Formulate the questions so that we are asked the ASG to formulate the questions.
Tuesdays, that can be completed on Tuesday. For that formation of
on Tuesday.
If you are ready right now, then again to list the matter, we can complete that because if his questions are agreeable to all sides,
there is some difference.
There is some difference. And ultimately, questions can always be reformulated in the final day.
We have no difficulty.
Let's see the questions.
All the appeals, we are given all of it separately. Each appeal, we are given the questions, relevant questions.
Take it on Tuesday. There's some difference between all parties.
All right, why don't you do this?
In Hyderabad,
why don't you do this? We'll formulate separate questions in the case of DIAL, separate questions in case of BIAL, MIAL and Hyderabad. MIAL and Hyderabad go together.
MIAL and DIAL go together.
MIAL and DIAL go together.
MIAL and
so
DIAL
what you can do is this. Have you formulated the questions that way?
Right, separately. Each appeal we have put.
Basically 3 categories. There are 3 categories.
Correct. Well, 3 categories.
And DIAL and MIAL are brownfield. Hyderabad, Bangalore are greenfield.
Because Hyderabad is not even involved,
Yeah.
Then there is Bangalore on one side, and there is Delhi and Bombay which are in one category.
All right. So what we'll do is this: if there are any track changes, you can carry out the track changes, indicate them to the learned ASG, so that once
that's better.
To the extent to which, and do this to the extent to which you are accepting their track changes, you accept them. just leave whatever you are not. They require a little bit of tweaking by us. We'll do that tweaking.
Please frame it on Tuesday, my lord. No difficult.
Your Lordship, permit us to do the same alone in respect of our three.
Now, what about this? You are for the Passengers Association.
So the Airline
Association.
So we have three appeals, one of DIAL, one
Are
of
there
MIL,
any separate questions really in the Airline Association?
Yes, Manoj, because the reason is we are a statutory stakeholder under the Act.
I know. We have just delivered judgment.
The questions may not change, my lords. The treatment to that question, of course, airline has a different treatment to it. But my lords, when the ASG, my lords, asks the questions.
Have you seen the questions ASG has formulated?
We haven't been.
Mr. Venkataraman, also do that. Give your questions. Probably your question may be subsumed within Mr. Venkataraman.
We'll examine that. Yes, Manoj.
And you can even sit with Mr.
We are ready to help anybody. We come on. And especially your Lordship judgment, para 58, has articulated how this should be done. So it's very important and it's going to help both of us in resolving the matter.
And once your Lordship sees those questions, your Lordship will realize that it is not as big as it is made out to be. It's a very neat question. Good
So
stuff.
Tuesday we will formulate the questions.
Please, man.
Your Lordship.
Extremely obliged.
Now,
Item 18. Any other?
Sorry. Well, item 24, Gamescraft also should go some other day only. Mulad.
Item 1, your Lordships were to.
in fact, you were not there in the morning. Should we
I'm
take
fine.
item 1? Should we take item 1?
Item 24, Gamescraft needs again to be a longer day.
That will have to be adjourned. Gamescraft, item 24, 25, you can push it beyond.
Obliged.
Now, your opponents are here, Mr. Solicitor?
Mr. Jaideep Gupta is here.
All right. Now, last time,
your Lordships were pleased to direct.
Let's see what it suggests.
This is the exercise. Can you give a copy to the other side? Or? Yes. Well, just I may
explain it.
That's what I was doing. Well, on the top, the column is law paper 1, civil. Then unique code. Well, this represents students. We also do not know.
We don't know who this represents.
Which student this represents. Then this is mark.
So, Mr. Solicitor, just to understand it, unique code 329192 in serial number 1.
Yes.
Is the same candidate as 416209 in the second paper, right?
Yes, yes. The entire line is of the same.
Right.
So, law paper 1, this 329192 gets 51.5. Then law paper 2, his unique code changes, but the same gentleman, he gets 48 marks in criminal.
51.5 is percent, right?
Out of 100.
Out of 100.
Out of 100. And this is 15 out of 50.
Right.
50. So, it starts from 50 and
now,
last
these
4.
candidates had appeared for law paper 1 and law paper 2 in which medium?
English.
They appeared
Yes, this list is English.
So 51.5%, 48%, and 15 out of 50 is roughly 1/3, 33%.
And as I have indicated to your Lordships, the
30%.
English question is, there are 3 questions in one paper. One is assessed by one district judge level judicial officer. Second question by one professor. And third question by another professor.
So each candidate in the English essay had to attempt 3 questions.
3 questions.
Not one question only.
Not one question, 3 questions.
So one was assessed by a district judge, level
officer.
Fair enough. Second was by an English professor 1 and third was English professor 2. Now, where were the English professors taken from? You had just, how many professors did you have actually total?
For everyone, 2 professors. The same professor assessed, but not everyone.
So question number 2 would be assessed by the same professor.
By the same professor.
Question number 3 would be assessed by the same professor for everyone. And these professors were from which institute actually?
University. Rajasthan government के professor
colleges में government colleges.
Rajasthan government colleges.
be a major variation between what they scored in the main 1, 2 and the interview.
And
it's not like that somebody in the main scored 80% and then suddenly in the interview gets 0%. Is there, I mean, you ask your officer because we'll ask you for your assistance. Is there any candidate who gets extremely high marks in the paper 1 and paper 2 and really gets very low marks in the interview? Sorry, in the essay,
I understand. Till he finds out, last page may be seen where in the essay paper the candidate gets 0. Proportionately, his marks in civil is 22.5. For example,
21.5 and 22.
And yes.
Let's quickly run through the marks in, let's see if somebody has got over 60 or over 70 in SLST.
Yes, I'll just quickly.
We'll quickly run through it. लगता तो नहीं है मेरे को.
Doesn't look. Down. And extraordinary high in the
Conversely, to that, 4 here, 4.9.
There is none, my lord, as per my instructions.
Just running through it, you can't see anybody like that.
In fact, the marks are going low. 499, you said. Yes.
This serial number 1549. Do you have this? Do you have that answer sheet of the essay? Can you be able to?
All answer sheets are here.
That's only.
Page 58 of
Yes,
compilation.
1549. Yes, Lord.
Do you
50, 50 and 5.
1549, just with a view to satisfy.
Then 1550 also, huh? Jamshid? 1550.
57, 1550.
1551 also.
Yes.
If you have it in your hand, we'll just take a.
My lord, all are here, my lord. All from 0 to 15. We can trace it out, my lord, but they are in.
Now they are in our custody.
Yes.
You can just ask the RG or whoever is here to just get the relevant trunk opened and get us that. Get us.
Can be done, my lord.
1549, 1550, 1552, 1552, 151 and 52.
Right, just a minute, my lord. Let me mark. 1549, 1550.
Yes.
1551 and 1552.
Just give us 1 second only. If there's something else, I'll let you know.
Even 1556 goes with the same.
In fact, even 1562 also.
Correct.
51.2.
And 1556.
1724. 1724.
1724. Yes. Yes, my lord. Lord, 499 also, my lord, may be of some interest to your lordship. It's converse case, my lord. But if your lordship would like to.
Which one?
499, my lord. It is page 19. Bottom is the pagination. Where in the law paper he or she gets, my lord, 4 civil. In criminal 5. But in language essay, my lord, he or she gets 11.
We can have a look at that.
Yeah.
41. No, 41 also, my lord. 11, 10, but in language it is 15.
$840.
Yes.
We'll just look at it in 2 minutes. I mean, this comes 1840, 1841. He gets 49.5 in paper 2, but 3 marks. 49.5 is a fairly good.
1840, my lord, and 1841.
Then solicitor 1911 भी देख लीजिए. That chap gets 49.5 and then 2.
Yes.
Just to see, I mean.
Yes, my lord.
Not that we are going to reassess the essay, but at least.
Just to get a glimpse of what has happened. But we can do that, my lord, in presence of some representative of the Registrar General of this court.
Years ago, there is a story going around. It's a true story. I'll not tell you the backdrop. There's an essay to be written on zoo. So the candidate in the court system who wrote on the zoo said, I went to the zoo on Sunday. There were many boys and girls. He actually said there were many boyses and girlses.
Boyses and girls. But I was told, my lord,
yeah.
Lord, we can do that within half an hour, my lord.
All right. So should we just keep it back for a while?
Yes. Lord, if my learned court master can instruct, my lord, in presence of some representative of Registrar General, we
will be there.
Yes, we can. We are all here, my lord. They will open it.
Or quick, big ticket number.
In item 7, if I may.
Yeah, if they also want.
We'll quickly see the essays. If there's something.
Well, as a matter of fact, this has nothing to do with this. But during the interview also, 2 honorable judges and 1 professor of law, they are sitting. Even they are not aware of the names. They are given only the unique code number. Unless they ask the candidate about the name, they would not be knowing the name.
No, that's not an issue.
That's not interviews are not
an issue.
That's not an issue.
This is the only issue there.
That's not an issue. I'm just saying that it's that.
Way of an example, one candidate who missed the cutoff only by 1 mark.
For what?
To sit for the interview, my lords. They get the aggregate. They are not able to reach to the cutoff. That is how it
can happen.
No, that can happen. Once again, there, if he suppose had scored very high, or she had scored very high marks in the language in the subject paper, but in the essay was very low.
Same, my lord. Same.
Then it's a problem.
That is the problem.
49.5 in law 1, 55.5 in law 2, and only 11 in language. And
which can you have the code number?
I don't have this chart, my lord.
Achha, 1 second.
Roll number is 5831.
No, 1 second. How much did she get in the first subject? In law 1, how much did she get?
49.5.
Law 1.
49.5.
Which number you are saying, if I can go?
Achha, interviews, how many did she get? Because we have got it in a descending order. Interview, how many did she get?
No, interview.
Sorry, I'm so sorry. Essay
11.
1 second. Because we have got the essay marks in a descending order, so it will be easy to locate it.
Yes.
There would be not more than, say,
11 would be.
Starts solicitor at page 13.
Yes, 30.
Now, she got how much in the in the language paper? Sorry, in the law one paper?
49.5.
And in the second one, 55.5.
55.5.
Okay, Mr. Solicitor, serial number 331.
My Lordship, there is one more candidate.
Yes. Oh, your Lordship may also like
330 also you can take.
330.
Lordship, there is one more candidate, Lordship.
329 also. 329 also we'll take, huh?
Yes.
Because that 329 gets 54.5, 48 and 11.
Lordship, there is one more candidate. There is one more candidate. Roll number is 536.
Roll number, sir, we will not have here. You tell us how much were the interview marks?
No, my lord. In paper,
sorry, I think I need a break for the
in law.
How much was the essay marks?
13. In law paper 1, he got.
One second. Interview, tell us how much.
13 essay.
Vince, wait a second. We just see if there's something there.
From the page 4, my lord, bottom.
Yeah. Plus, how much does he or she get in law paper 1?
46.5.
And law paper 2?
49.5.
110.
110.
And total aggregated 129.
110.
Just one more example.
Just remember your 110 in our serial number.
110, my lord.
110 in our list. Serial number 110.
Just one more example.
One candidate in the.
Just one example, if your lordship permits. The candidate is by 0.5, which this is Millard's petition number 19, item number 1 minutes.
Tell us how much interview marks did you get?
Yeah, English is 8. In legal 1 is 49.5.
How much you get in the essay?
8.
1 second, we go to 8.
The cutout is
starts at page 33. 33, 8 starts.
49.5 in legal 1, law paper 1.
Just 1 second. Huh?
I'm so sorry.
49.5.
49.5 and then 48 in 2.
921 and 48. 921.
Yeah. And then 8 in English. The cutoff is
921, the 49.5, 48 and 8.
And 8. And cutoff is 0.5. 130.5 is the total. So if she would have got 0.5, she would have made it to the 8.
My lords, in my case, which is a reserved category candidate, she's just missed for 1.5 marks. Her English essay marks is 10.
What is the interview marks, Manisha?
English 10.
Essay.
My lord, that would happen, my lord. Many candidates have missed, my lord, from
That's
the
okay.
minimum mark.
We are not concerned about the moderating. We are concerned.
I also like to see last 4 papers.
You got 10, right?
10 in the English essay, my lords.
How much did you got in?
Law paper 1, 35 and law paper 2, 40.5, my lords.
Just 1 second. Just go.
10 starts at page 18, my lord.
18, 19.
No, 19.
How much did you get, Manisha, in your law paper 1?
Law paper 1, 35, my lords.
My lordship,
Your lordship,
one at a time.
Your lordship, petition number 1 in serial number
1 second. We are on Manisha's case.
Sorry, my apologies.
35 and the law paper 2.
40.5 in law paper 2, 35 in law paper 1. English, she has.
1 second, we're just trying to locate your candidate.
608 possibly.
35, 40.5 and 10.
Yes, my lords.
But this is very low. You get
Just for 1.5. It's a reserved category candidate, my lords.
608
165 is the cutoff, my lord. So she just
Last
misses
4
the
also your lordship may like to see.
Last 4.
Last 4. My lord, please have those who have got the 0 mark.
It's one.
Just I am assisting the court. I am not.
22.5, 25 and 0.
So if your lordship would like to see how.
My lordship.
And gets 20 out of 100. Then you don't do.
Your lordship, petitioner in.
All right. Listen, we are not dealing with individual cases. We are looking at the trend.
My lords,
Just 1 second, all of you. Even if we have not called for the marks of a particular candidate, we are looking at the overall trend. Is it that somebody gets very high marks in the subject category and very low marks in the essay? That's what we are looking at.
One thing I have to point of principle.
You can ask them to do this exercise. Come here on Monday after we reopen.
I have to sum.
No problem. You will take all your we'll take all your marks in your enthusiasm. We'll keep this after we reopen on Monday. Let the interviews get over. We'll continue to do this academic.
Lordship, just last name. Just last name. My Lordship, last name. I am mentioning, my Lord. There is a boy who got marks in essay just 4.
तो क्या करें? ये लिखना तो क्या?
No, in paper 1 and 2 he got 52 marks.
Then tell us that. 4.
There is a in essay he got 4 marks.
4 starts at page 64. And what is paper?
Paper 1 he got 52 marks.
No, 44. In paper 2 he got 52.
44 and 54.
And essay he got 4 marks.
1732.
He's threatening to keep it on Monday.
2.
117.
42, 44, 52 and 4.
Yes.
4 marks and 50 marks in law paper.
So what is the reason?
There may be another reason. People who grade the law paper don't really focus so much on the English. They focus on the substance. A person who grades the essay paper looks only at the, the syntax, grammar, the language. He doesn't look at the substance as much.
No, I was
given, the substance, but
I was given one illustration, may not be in this exam, maybe in earlier exam. The English professor, my lord, told us that if a person being selected for this post cannot spell constitution correctly, I would not treat him to be a candidate, my lord, who gets. But that's the
person who got 0 in the essay, that is a very telltale situation. That will give your lordship an estimate of what, according to the examiner, is a 0 mark.
No, but
that's all right. Get some 0 essay candidates.
But that's what I said.
My lords, I have a reserved degree candidate with the candidates got 0.
Finished. You once said it registers in the computer.
Just item numbers, candidate, item number 6.
But given 10 marks in English.
10. Yes. 1 second.
Yes. 51 paper 1. 10 in the language.
Okay, give me the first number, first paper 1.
You said 10, right? In language?
Yes, your lordship.
ये पहले में कितना है? 502.
How much do you get in the first paper?
It's 51.
It's 502.
Yeah, got it. 51, 43.5 and
yes,
10.
This is a petition of reserved category candidate in item number 6.
Let's see these papers and get them.
Item number 6 in the reserved category, she is a candidate of a reserved.
Tell us how many marks in the interview.
Because in interview she scored in the English, the English exam, she got 5 marks only.
How many?
5. And then she is cleared under the reserved category, both law paper 1 and law paper 2. Milords, when she appeared without preparation in 2019, she scored 24 in English paper. And this time, Milords, just 5.
Is Anjali.
No. Just mark in the English paper, in the English essay.
25.
25 out of 50.
50.
Lord, can I add one thing?
English examination.
So you got 10, no?
5, Milords.
1 second.
Under the reserve category, I just scored 5, though I have cleared paper 1 and 2.
Oh, that doesn't matter.
Yes.
You just tell us how much did you get in the essay?
Milords, of English essay is 5 out of 50.
And
that's at page 558.
Yes. Now, where is the how much do you get in the first paper?
Milords, 38.5 in the law paper 1 under the reserve category. And law paper 2, 40 Milords under the reserve category. Hindi language, I scored 18. And English Milords, 5. Though I have appeared.
38.5, 42 and 5, right?
Milords, 40 and 5 Milords.
38.5.
40.
40.
61626 possible.
101.5 is the total Milords.
38.5, 40 and 5.
Milords. And in Hindi it's 18 Milords. Though Milords, when she appeared in 2019 without preparation, because it's her second attempt that time, in 2019 she scored 24 in English Milords. Though she could not able to clear the part 1 examination and part 2 examination that time in 2019.
Maybe the paper corrector also didn't understand too much of English.
But this is what
Law paper 1.
Depends on what the level of correction is.
But this is-
That's why Brother Mishra told me to ask the solicitor that what is the highest. So the highest was 25 out of 50. So it seems to be pretty tough correction.
My lords, one more request.
Lordship, may I?
Law paper 1. That copy can also be.
Because in my case, it was only missed by 2 marks, because just because of English, though I have scored very high marks in English in 2019 paper.
That would be for many.
We look at the paper. We look at the answer paper and see.
You
just get these in 15 minutes. They're not more than 15 that we have asked.
I don't think Manoj can be. Oh, all 7 boxes will have to be. No, there is 1 box lying here. That also we'll have to take.
Yeah, no problem.
Please.
But there'll be serial in the boxes.
Yes, Manoj. But possibly, Manoj, since there are many numbers.
The moment they are ready, just come, tell them to come.
Yes, half an, not more than half an hour, according to her.
In the meantime, pick up the name.
Small aspect, your lordship's attention.
After half an hour.
Obliged.
What is the next?
Not on marks, my lord, not on marks. Rule 23 of recruitment rule says number of candidates to be called for interview would be 3 times the number of vacancies.
Yes,
Mr. Solicitor, you can mention the moment you are ready.
Yes, sir. I was waiting for the next matter to be called up.
May I please? That affidavit has come, Manoj. And I'm afraid to say that there's been substantial perjury that has taken place in this affidavit. My lords have that affidavit?
Yes.
This is the
It's called compliance affidavit.
compliance affidavit of the chairperson DDA. There are 2 central points, my lords, which makes this entire sequence of events murky. And I believe that once this has been demonstrated, a formal notice of contempt will have to go. And I'll show your lordships. So please come to para 20. I'll keep it short. It's a lengthy affidavit.
Before that, there's nothing there.
No, that wouldn't be correct for me to say that. The visit is referred to, my lords, para 16
Right.
And
So that's where para 15,
Yes.
the affidavit formulates the first issue.
is yes. So, if your lordships see the last order of 16th October.
That's okay. They formulated what they respond.
They're formulated. So, whether during the course of the site visit on 3rd February 2024, there was any discussion with or intimation furnished to the chairperson of DDA on the permission required to be obtained from this court for the felling or removal of trees. Now, apropos that, the deponent's visit at the site of CAPFIM's project was scheduled with the object to take stock of the progress of the CAPFIM's project, keeping in mind the significance and necessity of the project as well as the resources, including the finances which have already been invested in this project. On the date of the visit on 3rd February, upon reaching the CAPFIM's hospital site and pursuant to a visual inspection, the deponent asked the officials present at the spot to expedite the work towards the completion of the project, being a project related to medical facilities for the paramilitary forces serving the nation, and resources to the tune of approximately so and so have already been invested from the public exchequer. The deponent, while coming back from CAPFIMS, had stopped at the site of the road widening. It is stated with utmost respect that no one present at the said site on the date of the visit brought to the notice of the deponent the legal requirement of obtaining permission from this honorable court for felling of trees. Upon inquiring the progress of work, the deponent was informed that permission for felling and translocation of trees is awaited from the competent authority. Therefore, the work of felling of trees has not been initiated. On this, the deponent informed that for the trees falling under DPTA 1994, the Forest Department had already taken approval of the Minister Environment Forests and Honorable Chief Minister with my concurring opinion. The deponent had observed that the concerned officials should expedite the communication of the approval in this regard to the DDA. In any event, the direction of the deponent by no stretch of imagination was to bypass the mandate of law. The deponent had also not issued any instructions to not take any permission wherever it was required by law. On the other hand, the visit on 3rd February, wherein the deponent asked the project be completed expeditiously, meant that all necessary actions required to be taken be expedited, given the seminal nature of the project. Thus, the direction to expedite the project on the bona fide belief that only permission from the Department of Forest and Wildlife, Government of NCT, was required, and for which the proposal of the Forest Department of the Government of NCT Delhi was approved by him. The deponent was also not aware nor made aware of the fact that further permission was required from this honorable court. On the other hand, the deponent was apprised about the various hindrances in the alignment of the road, which has to be widened. In view of this, the deponent directed the concerned departments to take necessary actions as A, B, C, D, your lordships can take as read. And then the next question, Manoj, in italics towards the bottom of the page. In the event that the answer to one above being in the positive, what steps, if any, were taken to ensure that the permission of this court would be obtained before the actual work of felling trees took place? In the event that the answer to one above being in the negative, when was the chairperson of DDA first made aware of the fact? Please mark this because he has perjured on this. Above being in the negative, when was the chairperson of DDA first made aware of the fact that A, permission for the felling of trees from this court was required, and B, the actual act of felling of trees had commenced on or about 16th February before an application was moved before this court, and which was eventually dismissed by the order dated 4th March 2024. Now, para 20. It is stated that the deponent was first made aware of the fact that permission for the felling of trees from this honorable court was required only on 21st March 2024. Please mark that date, 21st March 2024, when a proposal of DDA was received for constitution of a committee of experts in compliance with the directions of the Honorable Supreme Court in red petition so-and-so, wherein the application bearing IA so-and-so had been filed by DDA seeking permission for felling of trees for the said project. As regards the fact that the actual act, this is the second one, as regards the fact that the actual act of felling of the trees had commenced on or about 16th February 2024 was brought to the notice of the undersigned with a letter of Vice Chairman DDA dated 10th June 2024, which was issued pursuant to the directions of his Honorable Court. So this is the second one. So he first came to know about felling of trees on 10th June. This is what he says on a solemn affidavit in the Supreme Court.
And of the fact that permission was required on 21st
March. So these are the two things that he
Para
states.
20 is a key paragraph.
Para 20 is the key paragraph with reference to his knowledge. And thereafter, Manoj, which is also important, because what steps have been taken to identify the officers responsible is the next question, which is in italics below that. Regarding the willful act of suppression, whether any disciplinary proceedings have been instituted, initiating criminal action, whether the timber of the felled trees were inventorized, etc., etc. In response to the first three queries, it is stated as follows. On perusal of the records of DDA, it has come to light that the DDA has already constituted a committee to investigate the situation, that is the inquiry committee, which carried out a detailed inquiry into the matter and recorded the statements of all the concerned officials as well as the contractor. This report has not come on record from what I understand of the inquiry, because he says the inquiry has been conducted. In response to the above mentioned query, the deponent submits that the identification of erring officials of the DDA and the action of the suspension, disciplinary inquiry, etc. have been set out in detail in the affidavit dated 18 June, filed on behalf of the DDA. The following facts have emerged on record therefrom. The report of the said inquiry committee is revealed as follows. Instructions for felling of the trees had been given to the contractor by Shri Manoj Kumar Yadav, executive engineer, so-and-so. The officials responsible for permitting the trees to be cut by the contractor are Pawan Kumar and Ayush Saraswat. So these are two engineers, Manoj. Both are assistant engineers. C. It has also been revealed that the above named officers have been found to have allowed the tree cutting to take place on their own accord. Please mark that take place on their own accord, because they have now found scapegoats. D. It prima facie appeared that the officials responsible for suppression of facts from the Honorable Court on 4th March, when the application of DDA for permission for the project was heard, were Shri Pankaj Verma, Superintending Engineer, and Shri Manoj Kumar Yadav, Executive Engineer, who is the same person mentioned in A. The report of the aforesaid inquiry committee has also pointed out shortcomings in the existing mechanisms and practices, etc. The rest of this is about how things go forward. And para 23 deals with the show cause notices which have been sent to the officers at the site responsible for execution of the project. And they've submitted their written submissions, wherein it has been stated that they had misunderstood that the proposal received from the Forest Department of GNCTD and CEC recommendations to be the final permission to cut the trees. If I may pause for a minute, the DDA and all other authorities have for years been applying to this court for permissions. The CEC has been submitting reports on that. So the DDA can't suddenly claim that we didn't know Supreme Court permission. For 20 years, in both matters, the applications have been made again and again by all authorities. If I can continue. Since 1995, Manoj, in Godavari, they mentioned that the trees were cut, keeping in view the approval of CEC appointed by Honorable Supreme Court and letter of Principal Secretary dated so-and-so February 24, mentioning therein that under Section 29 of the Act, the area in question has been excluded from applicability of 9.3 and therefore DDA is exempted from the need to seek any further permission of the tree officer to cut trees. If I can see 24 and 25. Perusal of the sequence of events suggests that the field officials of DDA probably misunderstood the approvals received from the government of NCT of Delhi to be a go-ahead for felling of trees. The Forest Department issued a notification dated 14th February allowing cutting of trees under DPTA and a subsequent letter of permission of 15th February by the tree officer, following which the felling started on 16th. Though a mistake, the work done by them was bona fide in the interest of public good. However, the actions which have been initiated departmentally by the DDA against erring officials as well as the notices complaint under 2324 have been filed on 5th July before the learned Saket Court Complex, read with section so-and-so of BNSS against the erring official, thereby setting the criminal law in motion. The contempt has been initiated against the then Vice Chairman DDA Sri Subhashish Panda. It has stood placed on the record before this Honorable Court in the present proceedings that he was on medical leave for a major surgical procedure undertaken on him on 16th February AIMS. As it was a major surgery, even after resuming the duties on 2nd March, which was a Saturday, he was advised by the treating doctor not to attend the office physically and that he should work from home. He had rejoined the office physically on 12th March. Thus, having regard to this factual position and consideration of the affidavits filed by him from time to time in compliance with the orders passed by this Honorable Court, his physical presence was dispensed by the order date so-and-so. For the unfortunate event of felling of trees during this period, he was under surgery and medical treatment in AIMS. He was also not present at site under intimation to the undersigned due to his other official preoccupations, etc. Hence, the deponent submits that in this unfortunate event, there is no act of omission or commission on the part of the VC-DDA. Therefore, in the respectful submission of the deponent, the VC-DDA may kindly be discharged by the orders of this Honorable Court from the present contempt proceedings. And then regarding the felled timber is the next paragraph, which says perusal of record shows that regarding felled timber, concerned officials of DDA intimated tree officer the location of
now
felled
we've
trees.
seen broadly the affidavit.
Yes.
Now, what is it? How is it that you say that what is being
Yes.
stated is not correct
Yes.
or true?
Let me just first take your lordships immediately to the meeting that was chaired by him, my lords, on 12th April 2024. You'll find it at page 708 of this PDF. It's a part of the affidavit filed on 18th June by the DDA. It's at PDF 708. It's part of the affidavit. If your lordships have the compiled PDF, there's a single PDF. We've taken the court's file. It's PDF 708, printed page 334, which is a part of tab 3 perhaps. Tab 3, bookmark 3, affidavit on behalf of the Vice Chairman DD. Annexure K. Which one? Annexure K. K. When was the pen? See, now it's not 13, no, now it must be 22. Oh. Your lordships have the single PDF, the court's PDF for
We
this, for item 21, I'm sorry, for item
21.
Yes. Tab 3 in that, the pages have been updated.
There's one single PDF, is it?
Yes.
वो हमें क्यों नहीं circulate किया?
He's not updated. 711. 711. It can't be the same. Yeah.
What is this annexed here?
These are minutes of meetings maintained by the DDA.
It starts like this, note 1. Many infrastructural development projects are being undertaken.
Yes, yes. It starts like that on the first page. So internally,
the additional files.
If that is printed page 315,
it's a printed
yes.
one.
So then in that, my lords, if your lordships can come to printed page 334.
Beg your pardon?
334. Printed page 334.
334. So that will be 395. There are some notings in the handwriting.
Yes, yes. Well, this is PDF 395 of your lordship.
Yes, 395.
I'll just correct myself. We have a single one which has. So, yes. In the middle of the page, I'm sorry, it's not just MISRA has it?
Yes.
So, my lord, the Chief Justice has it.
Yes.
Yeah. So, in the middle, note number 14, your lordship, see?
Yes.
May be approved as proposed, please. HLG there is the chairman, DDA. This is 4:13 p.m. It's sent by the vice chairman. Your lordship sees that?
Yes.
Yes. Now, just below that, Honorable LG, this is handwritten. Manoj, have that?
Yes.
Honorable Lieutenant Governor has seen the proposal of the department and desired that exercise of alternate alignment of referred roads be completed in a time-bound manner. This is on 12th April 2024, well before 10th June. Below that, it's signed by the Secretary LG. VCDDA, below that, VCDDA, in view of our submissions on the matter before the Honorable High Court, we do not need to further proceed on the proposal ante. This was discussed in the meeting chaired by HLG and concurred to. Now, these are signed 12th and later 15th April 2024. Where will I find 18th?
these 2 pages, the proposal which was put up to the governor.
Yes.
And desired that the exercise of alternative alignment of referred roads be completed in a time-bound manner.
Yes.
So what emerges from that?
The reason why this becomes relevant is that your Lordship will recall that the cutting took place ostensibly as per the Vice Chairman's affidavit from the 16th of February.
Right.
We have reason to believe it started a little before that, but we'll take 16th as they say.
16 to 26.
16 to 26. Immediately thereafter, this started coming in the newspapers. There were photographs, etc. Based on which there was a contempt filed in the High Court. That's where it started, because in the High Court, a statement had been made by TDA that they would not be cutting off trees. So on 18th of March, the Lordships are looking at April now. In 18th of March, the High Court passes an order, which now again, it's at page 148 of the same. PDF 148. This is 18th March 2024. It's a part. It's annexure A6 of our contempt petition, which we had filed in the High Court. No, not us, but one of the members of public had filed it. This is in. Your Lordships have it?
No.
Oh, I'm so sorry. It's printed page 53.
Of the same compilation?
No. Compilation. I think your PDFs have been.
Now we have got the contempt petition with us.
Yes. In that.
Now we were looking at the additional volume in that.
Very well. Main paper book, page 148 PDF. 148 PDF.
Okay.
Because there's been many filings, Malons, I'm sorry. So, many affidavits, etc., etc. This is a High Court order dated 18th of March.
148 is a contempt petition in the Supreme Court.
Will you? Yes, 18th March. That's one. 18th March. That's one. Huh?
Main diary, page 54. Jasmeet Singh.
Yes, exactly. Which in the first paragraph notes the statement that had been made. The Lordship may note that at page, if printed page 53, the appearance is shown of Miss Manika Tripathi with Mr. Roni John advocates. I'm so sorry. Okay. This is slide 8.
Yes. How do you establish that when he went to the site on the 3rd of February,
Yes.
he was aware of the fact that there was.
So there are three different aspects here, if I can say.
Yes.
The first is regarding his visit, who all were present, whether he was appraised of permission being required. That is stage one. Stage two is when the cutting actually takes place, whether he had knowledge, etc., etc. Stage three, and that's why I had on the last occasion suggested that these questions come.
Yes.
Stage three is after the cutting, when the matter comes to the Supreme Court in the first round where DDA is seeking to press its application. I hope I'm making myself clear. When they then withdraw the application and go away without disclosing to the Supreme Court, that's already cut.
Cutting is already started.
The final stage is once you found out about all of this, what did you do as a chairperson? Now he says that, look, I had no knowledge at any of the prior stages that the trees had been cut. So he's saying two things in para 20. One, his discovery about permission being required. Second is about when he found out the trees were cut.
The first he said was 21st of March.
Yes.
Second was 6th of June.
10th of June. 10th of June. Now 10th of June, your lordship may note, even without going anywhere else, both these contempts, notice had been issued by the Supreme Court. It was on the front page of every newspaper in May. Both. But his solemn statement here is that he found out on 10th of June and not any date prior to that. And he says that he discovered because of
to him of something which appeared in the newspaper, etc.
No, I'm not attributing. Therefore, let's ignore that. I'm just saying, just generally everybody knew about it. You're the head of that organization. To claim that you didn't know when notice of contempt is going to your vice chairman seems a little bit of a stretch, but let's accept that. And I'm not going to rely on that. I'm just letting your lordships know this is the stretch to which they'll take. In fact, on 17th of May, Hindustan Times headline is Supreme Court puts DDA in dock for hiding data on tree felling. The order came while hearing a contempt petition against DDA Vice Chairman Subhashish Panda. So we'll presume that he doesn't know this. He doesn't know his Vice Chairman is being proceeded against for 1,000 trees being cut. He doesn't know about his entire organization. If such a man should be a chairman is a different question entirely. But let's presume he knows nothing about it.
We are now on contempt.
We're only on contempt. So I am saying that his statement, which he has made on oath, says that I discovered on 10th of June. Now, let me just tell you what the facts are. The meeting takes place in the beginning of February. Cutting takes place in the middle of February. Notice is brought to the High Court. The High Court takes notice of this on the 18th of March. 18th of March, that order which I was just showing your lordship had that on your screens, I presume. That sets out, in fact, photographs of which were taken on 29th of February, the violation of 31st August. Yeah. It takes note of the Supreme Court's order as well. And just see for a minute, pages 55.
Note of the Supreme Court order.
The High Court. In 18th March, the first order, where they made an application and withdrew for permission for tree felling. They take note of that as well. And the High Court, just if I can just show your lordship from para 2 at page 54 bottom, 18th March, the learned counsel for the petitioner. No, this is good. So on
But-
18th March, if I can just show you a lot.
And what we were thinking was that it's not that clear up to now from your submissions.
Yes.
Can you just give us a 2-page, maybe list of dates, a small note? Because on what basis do you say that crux was when on the 3rd of February was there?
Correct.
Was he aware of the restraint order of the court? You have said that when it was published in the newspapers, etc.
For that, that will be my second submission. I have one submission on that. But on this, just for half a minute, I'll just, without taking your lordships through much more.
How do we
On
establish?
18th March, photos of tree cutting are set out in the High Court's order. All of these, the same tree cutting, 18th March. Based on this, notice of contempt goes to the Vice Chairman of DDA and others, trying to explain why, after you've given a statement to this court that you will not cut, because they've made the statement recklessly in the High Court and in both proceedings in the Supreme Court, but they've gone against it. Why have you gone ahead and cut? Now, this date is 18th of March. Different matter. The next day, this is again headlines in whatever, Indian Express, etc., etc. Thereafter, the meeting takes place on 12th of April. The meeting notes, as your lordship saw, 12th and 15th. 12th is of the revised proposal regarding this project. And who is putting that proposal up? The vice chairman to whom this has gone. The contempt notice has gone. Where the LG chairs the meeting of 12th April. LG is told about the cutting of trees on 12th April because in the 10th June letter that the LG is referring to, which is also on record, I'll show you that. The vice chairman DDA writes to the chairman DDA on 10th June saying, I told you on 12th April that we have cut trees. Can I show you that sentence? Once the vice chairman has said that to the chairman, for the chairman to file an affidavit here saying, I didn't know till 10th June is extremely strange.
He said, I didn't know till the 10th of June.
Yes. Para 20 itself, where your lordship was saying, I'll read that sentence. As regards the fact that the actual act of felling of trees had commenced on or about 16th Feb, was brought to the notice of the undersigned, vide letter Vice Chairman dated 10th June, which was issued pursuant to the directions of this Honorable Court. So until this Honorable Court issued directions,
he didn't know.
He didn't know. Your question was very clear. When did you get to know and what did you do?
So what is the vice chairperson, what does that say, that letter that I pointed out to you on the 12th of April?
I'll just read the entire sentence. Show me a relevant sentence. It's 2 paragraphs. That's page, Annexure L, page 778 of the PDF.
And Annexure L of what?
The same additional documents volume that your lordship were looking at.
Page 778.
You were looking at Annexure K, the first thing I showed you. Annexure L, the one immediately after that. It's page 401 of that, printed page 401. Ah, that same one, same one. Internal page 3 of that. I have it here. Page 401, bottom. When the, I'm sorry. My lords have it?
I didn't know of the fact that, the tree felling had taken place. Now, if we see the letter of the Vice Chairperson to the Lieutenant Governor, that is of 10th of April. That is of 10th of June.
10th of June. 10th of June.
Now, that letter at the bottom of printed page 401 says, when the file having the proposal for constituting the committee of experts was received from your good office with the approval of your good self on 12th April 2024, I had already brought to your knowledge that the blunder of felling trees has been committed by the officers of DDA. That means on 12th April 2024, he is apprised with the fact that the blunder has taken place. But he tells us that I got to know only on 10th of June.
I'll tell you, Lordship, that's a little bit of
How can you say that? And this is not, it could be that the Vice Chairperson is wrong and the LG is right.
We are not saying that at all. Lord,
But the Vice Chairperson says on 12th April, you had actually approved the proposal for constituting a committee of experts.
Right.
Committee of experts, why? Because of the order passed by this court, rejecting the application and saying constitute a committee of experts.
Lord, I'll explain what it's a little bit of hair splitting that my learned friend is wanting to take. What the learned LG has said, if you the vice, just have a look at that affidavit, Lord. Just see that page. Just see paragraph 20, the very line which my friend is so heavily relying upon. As regards the fact that the actual act of felling of trees had commenced on or about 1612 was brought to my notice. So the exact date on which the felling, because it could have been 1612, it could have been Lord 4th of March. 16. So it's only the fact that 16/2 it started. It came the exact date of felling. Not Lord as if I didn't know about the felling. That is one. And can I just give your Lordship a little bit of background?
PC's letter says that when the file having the proposal for constituting the committee was received from your good office with the approval of your good wealth on 12/4, I had already brought to your knowledge that the blunder of felling trees has been committed. Therefore, it was brought to his notice sometime prior to 12th of April.
I'm so sorry, Lord, I'm not being able to make myself clear. What I'm wanting to submit to your Lordships is this, that he's not saying that he didn't know about the felling of trees till 10 June. He's not saying that. He's only saying that the actual felling started on 16/2. I came to know only on this date. The actual date of felling, that's all that he's saying. I mean, it's a little of hair splitting which my learned friend is wanting to do. It's not saying that I didn't know. It's only saying that it actually started on 16/2. I came to know by this date. Because even prior to the application which was taken up by the Supreme Court.
When was he first made aware that the felling of trees had taken place?
I would presume, Lord, 21st of March, because 21st of March, Lord, this question of Supreme Court permission having not been taken and was required, obviously that would be the first date. Can I just give a very small background to your Lordship, Lord? Very small background.
Question put by your Lordship is,
to look at the larger
the event that the answer to one above being in the negative, when was the chairperson of DDA first made aware of the actual act of felling of trees?
Maybe it's not very happily. I'll just give your Lordship very small background, Lord, then your Lordship will understand the conspectus in which, Lord, this whole thing has happened. Nobody can defend, Lord, what has happened. There is a clear case of contempt, but who has committed is one question. And secondly, Lord, whether your Lordship would like to haul that person in comment or would want some remedial action to be taken because these trees have gone. Just a small background, Lord. Between 2003 and now, about 172 acres have been diverted under orders of this court for setting up various institutions in that area. So that is, Lord, the SARC University has about almost 100 acres. Capfins has about 50-60 acres. Similarly, Lord, I have a list of, Lord, what all is there. There is the IIFT, Lord, there is a Delhi Police housing, CBI housing, and SARC University. Now, all this was created in this patch of area, which was, Lord, not having trees.
Now that patch of area is surrounded by forest from all three sides. All three sides. There is one 7.5 meter road which is reaching there. Now, when you gave this approval, obviously you realize that you'll have to improve this road because 7.5 meter can't cater to all this, especially the hospital, because it's a 937 bedded super speciality hospital only meant for paramilitary forces, because your Lordship knows Army has a special facility. Whereas these paramilitary forces also will not face these Naxal actions, etc. And they don't have any such special facility. So this was envisaged as a special facility for these only army, these paramilitary forces, that when they are injured in action, they should have a super speciality hospital rather than not running from pillar to post to go to AIMS or to the local hospital wherever they are. They can straight away flown in here and treated here. So this hospital was planned. Permission was given by this court. But Lord, obviously, when the hospitals was started to be constructed, the road was not required for the purposes of what the road will be utilized, what will be required not for the purpose when the hospital becomes functional. So 7.5 meter road was there. That 7.5 meter road was sufficient to do the construction. So the construction happened. Now, Lord, I have been.
They've withdrawn the project before this court. They've withdrawn. It's already
No, that will be there. It will have to come. Lord, that can't be given up. It can never be given up. I'll tell you because
before this court and this proceeding.
I'll explain. Lord,
now he's trying to reopen that as well.
It will have to be. Lord,
he's an individual. He has to respond not for the DDA for which Mr. Singh is appearing. He has to respond.
Both of us are appearing for the DDA because your Lordships have called for his affidavit as chairman of DDA, so we are appearing, Lord. I am appearing in one matter. My friend is appearing in the other matter. So, Lord, this. Students. MOU with the All India Institute of Medical Sciences, Lord, your Lordship knows not All India Institute doesn't require an MCI permission or a NMC permission. So 250 medical college has to come up and 937 bed lot super special. And these are all ready, unfortunately not being inaugurated because of this our completely avoidable controversy. This could have been clearly avoided, because if you had gone for this permission on 4th March, if the cutting had not taken place, one could have easily come and justified and the whole thing could have been given, permission could have been given. We are actually going on a tangent because of this illegality which nobody can justify or defend that has happened in the cutting of trees. Now, Lord, as far as this area is concerned, that approach to this area is concerned, it has two authorities where tree permission is required. For the morphologically frail area, we require permission of this court, and which is not a frail area, Delhi Trees Act permission is required. So these are two authorities which gave permission. The Delhi Trees permission can be given by the LG because ultimately that is not something which comes to this court. So 422 trees were permitted to be cut by the LG's order, which is under the Delhi Trees Act. These trees are all along this road. Some areas you require Supreme Court permission, some areas you don't require Supreme Court permission. Now, Lord, I have been in this matter, Mr. Shankar Nayan also has been in this matter. It's in this court, and unfortunately, this was the practice, Lord, which we used to follow, that a CC report normally used to mean a Supreme Court approval. So if your Lordship will historically go back the orders of this court, CC report, your Lordships would say approved. And that is the only order which normally used to be passed. Unless if your Lordships felt in a particular case, like in this case, your Lordship felt that more effort should be taken. No, not 17.
Yes.
What you do is this.
Yes.
Your case is that on 3rd February he knew that
Yes.
permission was required, he has denied it.
Yes.
The chairperson says that, well, I got to know for the first time on the receipt of the letter of 10th of June. Prima facie, that may not be correct because the letter which was addressed to him on 10th of June says, I already pointed it out to you on the 12th of April of this blunder which had taken place.
Plus the High Court order.
So at the least, the chairperson knew about it
Yes.
on sometime on the 12th of April.
Yes.
And that's why on the 12th of April, the alternate alignment is sought to be Oxford. Theory of alternate alignment arises only because there was some, because in the event that there was some injunction.
Yes. Yes.
Now, we are only on this, does it go back to 3rd of February?
Yes.
When the direction for, clearing and etc. was given.
I'll explain why a little bit of clarity is required on record for that, which is this, that on the 1st of March.
Why don't you do this? Can you just prepare maybe for us a list of dates?
Yes.
With the page references now.
I'll do that.
And we'll keep it on Tuesday.
Very well.
After we reopen, because that will bring some clarity.
So, if the Lordship permit, I'll also make a list of it, giving the entire picture, so that your Lordship will appreciate in the proper perspective, Lord, how this whole area has come up. And
I'm clarifying this is limited to the contempt issue. We are not on the larger issue of the project and how important it is.
Ultimately, Lord, that also will have to be done here only.
The contempt of the Supreme Court is the contempt of the Supreme Court. Nobody can wriggle out of it by claiming justification.
Affidavit, and the affidavit, an affidavit dated 22 October 2024 has been filed by the chairperson of DDA in pursuance of the order dated 16 October 2024.
Ex officio chairman, Your Lordship, is actually
paragraph 20 of the affidavit. Don't say para 20.
Would Your Lordship permit me to file a better affidavit? Then I think that will be better, that will be more, Lord, because this is actually not saying that I came to only on that day. It's only saying that the actual filing date is that. That is what he's saying. I can only explain if Your Lordship permit me.
In the order of this court, the chairperson was specifically called upon to disclose, page 9 को AA copy कर दीजिए, हाँ? In response to this query, the chairperson has stated in paragraph 18 of his affidavit that when he visited the site on 3 February 2024, while coming back from the CAPF IMS hospital, he had stopped at the site of road widening, but no one present at the site on the date of the visit had brought to his notice the requirement of obtaining permission of this court for the felling of trees. The relevant extract from the affidavit reads thus. BB, para 18, page 10. The next aspect on which a disclosure was sought was about when the chairperson of DDA was first made aware of the fact that A, permission for the felling of trees from this court was required, and 2, the actual act of felling had commenced on or before 16 February 2024, before an application for permission was moved before this court and which was eventually dismissed on 4 March 2024. Stop. On this aspect, the disclosure in the affidavit of the chairperson of DDA is set out in para 20, the relevant part of which is extracted below. CC para 20, page 12. Good stuff. During the course of the hearing, full stop. The above extract seems to indicate that the chairperson,
If your lordship permit.
that the chairperson was made aware of the fact that the actual act of felling of trees had commenced on or before 16 February 2024 by a letter addressed to him by the Vice Chairperson of DDA on 10 June 2024. Let's stop. The letter dated 10 June 2024, addressed by P. Subhashish Panda, IAS, Vice Chairperson, DDA, to the Chairperson, forms a part of the record. Let's stop. The relevant part of the letter reads as
Lord, if your lordship will have 401, actually the 16th February date is coming in this letter only.
Two paras above that at 401. The cutting started on 16 February, just two paras.
And your lordship's question very specifically is, if your lordship just see the question, because I don't want, Lord, because it will become, once your lordship put it in the order, it will become, just have a look at the question once again, Lord. The question is, the act of felling of trees had commenced on or above 16th before an application. So 16th it commenced, when did you come to the table?
Date comes on 401.
That comes in the same letter.
which part?
Just see that letter, Lord.
I got it. Page 401, which part?
Second para. Third para.
Second fresh.
Unfortunately.
Yeah, no, the CC means.
As was learned later.
No, second next para. 16th. Yes, I'm learned, sorry, yes. However, as was learned later, it also transpired that the field's staff contractor.
The letter of the Vice Chairperson indicates that the
you're right.
felling of trees commenced on 16 February 2024, into invert commas, onwards for about 10 days.
Is admitted by them. So this is the date when he is informed.
That is why the last para comes.
That's not the question.
However, the letter contains the following statement. Copy down the last para of the letter in the additional paper book at page 463 PDF. When the file having the proposal, यहाँ से शुरू कर दो, up to 460, ये आएगा आपको 462 bottom, till the end of the para on 463. The file was marked down to the EM. The above statement in the letter of the Vice Chairperson indicates that the proposal for constituting a committee of experts was received in the office of the chairperson, was received from the office of the chairperson, duly approved on 12th April 2024. The Vice Chairperson states that at that stage he had already brought to the notice of the chairperson, into brackets, the blunder of felling of trees, into invert commas complete, which was committed by the officers of DDA. February 2024, the executive engineer SMD-5/DDA addressed a letter to the contractor expressly stating that the trees which were present in the right of way into brackets ROW may not be felled till the permission is granted, and the work shall be taken up at those locations which are free from any hindrance. The letter further stated that the approval for tree felling would be conveyed in due time after approvals were received. Full stop. It appears that it now appears clear that the felling of trees commenced on or about 16 February 2024. If this be the position, the primary question which has to arise is who sanctioned the felling of trees? Full stop. While the chairperson states in paragraph 20 of the affidavit that he was made aware for the first time on receipt of the letter of the Vice Chairperson dated 10 June 2024 that the actual act of felling had commenced on or about 16 February 2024. Prima facie, it appears from the file that on 12 April 2024, it was stated that ये आपको पेज 395 को मिल जाएगा PDF, into inverted commas, Honorable Lieutenant Governor, LT Governor, has seen the proposal of the department and desire that exercise of alternate alignment of referred roads be completed in a time-bound manner. Full stop. If this be so, the statement in the letter of the Vice Chairperson that the facts pertaining to the felling of trees was communicated to the chairperson before 12 April 2024 would seem to be borne out from the record. Consequently, the statement that it was only on 10 June 2024 that the chairperson was apprised of the fact that the actual felling of trees had commenced on 16 June 2024 would require, on 16 June 2024 would require, 16 February 2024 would require further clarification. Full stop. The furnish a further opportunity to the chairperson to file a. We further call for affidavits, specifically from the Vice Chairperson of DDA.
Ex-Vice Chairperson.
The former, from Sri Subhashish Panda,
yes.
IAS, former Vice Chairperson of DDA, semicolon, and bracket 2, by the chairperson of DDA on the above discrepancy. Stop. We also direct that with all the original records be produced before this court and permit inspection to be taken of the files by the counsel appearing in the case. Full stop. The affidavit be filed within a period of 1 week, list on Tuesday. On or before Monday, Kardo, and list.
No problem. Just one small issue.
Second,
Last order.
1 second, Mr.
Just 1 minute.
1 second. My lord, the affidavit will come. But if your lordship see the frame of your lordship's question, and then that page 401, the upper part and the lower part.
The question is,
got your point. You are saying on
satisfied.
16th February. When did you get to know that 16th February?
the date of actually commencement of
That has
Both
come for the
your
first
lordships
time.
can clarify because
will
they're trying to
clarify
create
it.
confusion where there isn't any. Very clearly, when was the date that each of these individuals got to know about tree cutting?
can
So
do
there
that.
can be no confusion anymore since they're filing a better FLC.
Specific disclosure. We direct a specific disclosure by both the former vice chairperson and the chairperson DDA of the specific date on which they obtain knowledge of the felling of trees.
Just one.
One last thing, excuse me, just a minute. Last order, your lordships had reiterated that report of the Forest Survey of India, FSI, no? FRI, had to come. That still hasn't come, my lord. Just once more, because your 24th June order said that the final report will come by mid-August. They are supposed to give an evaluation of the number of trees that have gone, and they do satellite images.
The Forest Survey of India shall parenterally submit its report before this court within a period of within a week from the date of this court.
Lord, your lordship have dictated the order, Lord. I didn't want to interrupt. Just have a look at the.
We have only pointed out a discrepancy.
I appreciate, Lord. It's a.
We have not said that there is any
No, I appreciate.
statement. Right?
Totally appreciate. Only one, because I don't know.
Yes.
I should feel today itself. Then probably.
Yes.
Just have a look at the question and then.
No, there's much more for me to say,
Page
my
12.
lords. There's much
Page
more for
12.
me to say. So let them file that affidavit. He feels that we can close it.
Give us a
Very
small
well, I'll
list
do
of
that.
dates because that will bring clarity to us.
But otherwise, Lord, if your lordship will see, the question was the actual act of commenced on 16th. When did you come to know?
Then it says on the 10th of June.
The actual act which came to the came.
Mr. Solicitor, you've got that those essays. Let us see some of those essays now. This. Show this. Solicitor, don't read it aloud, please. We are passing it to you on the assumption that you will not read it aloud.
No.
Look at the first line.
Your lordships had an occasion to.
No, just read only the first line of the first paper. That word begins with the word letter IMP. First line.
Why should it take so much time for you to read it?
I don't think they were very strict, my lord.
Numbered, I just received.
That without the judiciary, there is no other option to control or reduce crime in any country. Who is Justice Krishnaswamy? Maybe Justice Krishna here became Krishnaswamy here. Judge means the person who is empowered by law to give. After a quick
checking with SA reverse exactly. The might pull out something like this. It's all right. Just putting it on.
In mind, my lord, that
These
these
are exam-
candidates are going to be the judges.
And these are exams for people to
Judges.
become judges.
That's the consideration which appears to await.
By the previous order of this court, the High Court of Rajasthan was directed to produce in a tabulated form the marks obtained by candidates in law paper 1 bracket civil and law paper 2 bracket criminal, together with the language marks, or together with the marks in the English essay, in respect of candidates who had appeared in both the law papers through the English medium. Responding to the submission of the petitioners that certain candidates had received extremely low marks in the English essay, it was necessary for the squad to prima facie scan the data to indicate as to whether there was any wide variation between the marks obtained in the substantive law papers for which answers were given in English with the answers in the English essay. Full stop. Accordingly, the High Court of Rajasthan has produced a tabulated sheet running into 73 pages in compliance with the order, tabulating the results for those candidates who received 15 or less marks into brackets out of 50 in the English essay examination. Full stop. It must be noted that the disclosure was sought in respect of those who had received less than 15 or less marks in the English essay examination. 15 or less marks out of 50 in the English essay examination. Full stop. Looking at the full stop, after scrutinizing the tabulated, after scrutinizing the tabulation, which has been submitted to the court by the learned Solicitor General, we had also directed the Registrar General is present here, no? Registrar General or Registrar Vigilance?
Additional registrar.
The officials of the Rajasthan High Court who are
exams.
So we'll say the officials of the High Court of Rajasthan who are present before this court to make available the answer sheets in the English essay examination on a random selection based on a comparison of the marks in the substantive law papers and in the English papers. Wherever it appeared that there was a disparity between the comparative grading. Full stop. 7 trunks of answer papers. You need not say that. Peruse the answer sheets which have been placed for the consideration, placed for the perusal of for the scrutiny of the court. Full stop. Based on the nature of the answers in the English essay, we have no manner of doubt that there is no prima facie substance. There's no substance even prima facie in the allegation that there was a deliberate low marking in the English essay paper. Stop. Next. The Solicitor General has applies the court to the fact that 3 questions were required to be answered in the English essay. Full stop. For all candidates, the first question was assessed by a district judge level officer, while the second and third, while the second question and the third question respectively were directed to be assessed by distinct sets of English, what the English
Professors, my lord, are working in the
English
government.
teachers.
Professors working in government colleges.
Working in a government college to obviate any disproportionate marking. Full stop. Don't see to obviate disproportionate, to ensure the fairness of the process. Full stop. Based on the tabulated position which has been disclosed before the court, we find no statistical discrepancy of nature that would warrant the invocation of the jurisdiction under Article 32 of the Constitution. Full stop. Besides, as noted above, the marking of the essay does not suffer from an error of a nature that does not suffer from any from an infirmity of the sort that would cast doubt on the overall assessment of the English essay answer sheets. So we therefore decline to entertain these petitions.
There's one more aspect that we have raised in item 1, Milords.
Yes.
There are marks that have been given in the answer sheet which do not tally with the scorecard that has been published, Milords. We put an instance in our writ petition. In the answer sheet,
how many people?
We just had one instance from the last examination.
That was previous
examination.
If there is any other individual grievance in regard to if any candidate has an individualized grievance, save and except for the issue which has been concluded by this order, liberty is granted to move the Rajasthan High Court in the exercise of its jurisdiction under Article 226 of the Constitution.
The Lordships may record
required number of candidates. They are not being called in ratio of 160.
That also you can,
that is there.
that you can find. We have only closed this.
No, my lord, there are 222 posts. The advertisement says that we will call 3 times the number of posts, and we have the eligible candidates who are crossing the threshold, which is 3 times 222.
The Secretary General is requested.
My lords, in the reserved category, that they are not called. In reserved category, 177 are required to be called. However, 133 are called.
It's permitted to hand. The Secretary General may now hand over the trunks containing the graded answer sheets for the English essay to the team from the Rajasthan High Court, which had produced the files.
Please, grateful.